file this urgent petition lawsuit.
What is urgency?
The urgency lawsuit is that the petitioner is a 80-year-old cancer patient who is also unmarried, who has no one to look after. Now his bank account, savings bank account, fixed deposit, everything has been debit freeze by the bank without any intimation whatsoever.
Leave is granted.
Would you kindly direct the matter to appear on Friday? I shall serve and come back.
Friday?
Friday, Your Lordship.
File in due course then, give the number. File in due course and give the number. Today we are on Wednesday, it will automatically come by Friday.
So if it
It
can
will appear under the upgraded heading on Friday.
Your Lordship, leave may be given so that the leave may be endorsed.
It is
Your Lordship.
required. Then leave the
I'll give the number to your officers.
Yes.
My lord, under compelling circumstances, may I be permitted to mention, my lord, item number 785, my lord, of the monthly list, my lord.
Yes.
My lord, I have filed a civil revision, my lord, against the order of the trial court, my lord. It is fixed today, my lord. My lord, kindly
Mention
take
on the
some-
last day I refused you.
Yes, my lord.
Intimate to the court below that I'm in season of the matter. It is pending. No.
My lord, in that case,
Please
I
call
have
on the
to
list.
try my luck in another court, my lord.
For
Kindly
judgment,
release
item
my-
number
I
one.
won't release the matter on that ground. Yes.
For judgment, item number one.
Lordship, there is one urgent matter.
Keeping in view the above observations, WPA 12098 of 2023 is disposed of by directing the respondent authorities to ensure that medical officers of the Hooghly District Correctional Home regularly check up the physical and mental health of the prisoners. Routine checkups both on the psychiatric and physical fronts must be undertaken for every prisoner housed in the said correctional home, including the petitioners, at least once every 2 months, and necessary medical facilities be extended to them in the event so required over and above the medical checkups. The jail authorities shall also ensure that basic amenities are available to the petitioners. Respondents shall also ensure the petitioners' right to have interviews with their relatives and friends as well as with their lawyers, as and when so required, subject, of course, to the rules framed in that regard by the state government, and having regard to the question of security measures and safeguards against smuggling of contraband, but not less than once a month as prescribed in section 51(1) of the 92 Act. The petitioners, however, are given liberty to apply to the Inspector General of Correctional Services under section 64 of the 92 Act, if they so wish, for being transferred to an alternative correctional home. If such applications are made, it will be open to the IG of Correctional Services upon undertaking proper inquiry to consider such application and take a decision thereon at the earliest in accordance with law. No address to cause urgent certificate. I'm sorry, I've refused your prayer.
So, all right.
Yes.
Do we mention item number two? Non-prosecution.
My lord, I am
Yes.
moving in person, do not want to proceed as the matter has been settled between us.
The petitioner seeks to appear in person, which leave is granted to the petitioner. Full stop. It is submitted by the petitioner that he does not want to proceed further with the matter. Full stop. Accordingly, WPA 10162 of 2021 is dismissed for non-prosecution without any orders to cost. Thank you.
Item three for release.
Lord, I beg to appear for the petition.
Yes,
in this
Mr. Kormakar.
matter. Lord, this is the affidavit service. Lord, the only ground, Lord, for release is, Lord, similar, Lord, this is a claim of
Yes.
area rents against the income tax authorities who was lessee.
It's pending before Justice Nijamuddin.
Justice Saraf.
Justice Saraf.
Sir, Lord, the claim is from 92, but this petition restricts itself from 2016
Right.
onwards.
Learned
main adjudication-
counsel for the petitioner submits that that a connected matter on the same issue, on similar issue, is pending before a different coordinate bench of the Honorable Justice Sharaf. Full stop. Accordingly, he prays for release of this matter for the purpose of being tagged with the other matter. Full stop. Acceding to such prayer, comma, WPA 28868 of 2020 is released from my list with liberty to the parties to seek an assignment before the other bench taking up similar matter.
I'm grateful. Affidavit service. I have
Affidavit of
filed.
service filed today be kept on.
I'm grateful.
Item four.
Yes, Dr. Shah.
My lord,
Appear for the medical counsel.
I filed this matter 2.5 months ago against the medical council, my lord, coming all the way from my permanent residence in
Yes, you
US.
want a
Yes, all I want to, the main writ petition, I understand, won't be decided today, but so that I can continue doing this case via video conference. There is one thing, there is an ad interim prayer. I'll take your lordship 3 minutes time. The why this ad interim prayer? I'll just show one piece of evidence. which should speak for itself.
Dr. Shah, no, in the garb of this, I cannot permit.
Just 3 minutes.
What is the nature of the identity?
Because that one piece I will show you, they formed, the president was selected when none of them were members.
So for an identity model also, Dr. Shah, you required to go into the matter at least prima facie. So let us do that by video
Your
conference.
lordship can decide, just give me thing, just see that one piece of evidence.
Under to be mentioned, no.
Then you can pass the same order.
When are you leaving the country?
Maybe 2 more weeks, because I'm here almost 3 months now, my lord.
Dr. Shah, I'll keep it. What is the urgency you said?
Because the council functioning with a president, who is the supreme power of that, who was elected before any members were members. So I will show you that.
I'll keep it under the upgraded heading. Let us see whether we can do it within 2 weeks. If I can't, before the end of 2 weeks, please just mention it so that I'll give you that leave to do it by video conferencing. I'll keep it on the upgraded list tomorrow. But it will be some, I mean, at the bottom of the upgraded list till now. So let us try our luck. If I can't reach it, for the identity model, at least I have to take up the matter, or I may dispose it off also when I take it up, if I can take up. If I can't reach, after the end of 1 week, say, or 10 days, please just mention. I'll give you that liberty to move it by video conference.
At least for the identity.
In view of the
But the-
urgency involved, yes.
May I just indicate the
I'll just keep it under the upgraded heading. No interim order.
It's the affidavit of service.
I'm not recording anything on merits. In view of the urgency pleaded, let the matter appear in the list under the heading upgraded matters. What is this?
Affidavit of service.
Affidavit of service filed today be kept on.
Grateful. Grateful.
কালকে upgrade list এর তলায় দিয়ে দাও।
so grateful, my lord.
প্রথম লাইনে একটা অ্যাড করে নেবেন মাধব বাবু, leave is granted to the petitioner to appear in person.
Item 5 for release.
In item number 5, I'm for CSC. We don't know why this matter has been released. But this is a third round of litigation, and your lordship was pleased to pass the order in the 2 round of litigation.
Probably due to the urgency, I'm not being able to take up that maybe.
Can
No, I'm not releasing any further matter
Yes.
because the other benches are cursing me for that.
no,
Because
kindly don't
everybody is
release
equally
that.
placed.
Yes,
So I cannot do that now.
yes.
I'll put it in the upgraded heading. None appears for the petitioner, although the CSC Limited is represented through counsel, full stop. In view of the apparent urgency involved, let the matter appear under the upgraded heading. Upgraded heading, just tell whoever is there,
Lordship, one indulgence, my lord.
no indulgence. Upgrade থাকবে মানে কাল থেকেই থাকবে। Yes,
Extension of interim order, item 6.
yes, Mr. Vasu. Expiring when?
31st.
31st. Yes, Mr. Paul, Mr. Paul.
Paul, yes.
He's now Mr. Paul. So
He's assisting me.
yes, Mr. Paul, you are appearing with you. In view of the interim order being due to expire on August 31, 2023, upon hearing the submission of learned senior counsel appearing for the petitioner, let the interim order stand extended till October 19, 2023 or until further order, whichever is earlier. Full stop.
The only thing, my lord, in spite of repeated reminders, but they have not filed any affidavit till date.
I'll put it in the monthly list of September for hearing.
If possible, you have to hear.
I'll keep it in. Let the writ petition be listed for hearing in the monthly list of September 2023. Let it be there. Let us see.
Why these ornaments?
Pardon?
Why these ornaments?
What ornament is? I don't know. I only requested them to put a use me placard in the microphone for people like you.
It remind me.
But they did not do that, but this has been done. No, I am minded. আচ্ছা অরিত্র
But
শোনো
at least this court,
এই মাঝখানের এগুলোকে সরানো যাবে কি?
but every court has removed it.
That is not a consideration.
No.
Then I'll keep it.
Then remove it. There is no barrier between us.
No barrier. They may feel unsafe from
No.
advocates.
Till
Some advocates.
75 is the last 75 years is going on.
No,
Why-
the trend was different previously.
But
Then
I-
you were not a senior advocate at that
That's
point.
true. So more dangerous.
More dangerous.
I now resistant.
এই অরিত্র শোনো না, বলছি এগুলো সরিয়ে দেওয়া গেলে আজকেই বলে দাও যে করে দিতে,
These
কালকে
also.
যেন না।
But
Sorry,
at least this
ফালতু
court,
মুখটা ব্লক হয়ে যায়।
well, at least this court, after hearing the matters, can understand who is petitioner and who is respondent.
Not
So
necessary.
this is
Not
not-
necessary.
This is not necessary.
No, Mr. Vasu, you be there throughout the day, you won't be able to understand some cases.
This
I assure you, you won't
This
be able to
happens with Justice Bhaskar Bhattacharya. Justice Nirjhat put it. When his lordship retired, Justice Bhattacharya stayed the chair.
on the particular day, I purposefully stand wrong side. The court officer asked me, Saptangshuda,
No, actually, I
for
did
the
not
appellate."
notice this before you pointed out.
Then
I hadn't noticed this.
as usual voice says the court officer, আরে বাবা এই জজ মামলা শুনে বুঝতে পারে কি appellate. Justice Bhattacharya, sir, hey, remove it.
No, this is so many people are appearing in person nowadays.
So what?
This is for
But
them.
this is a demeaning to the judges. They cannot understand who is for
Why?
the petitioner.
No, we can't understand. That is accepted. There is nothing demeaning about it.
Can you consider can remove these things?
If we have to understand who is for the petitioner, then
Many
no
issues
role of the advocate.
Without this poster, why now?
No, but don't claim to anybody that because of you I have removed.
No. At least code number 19,
sir.
I removed it.
These structures will be these writings they don't matter. Mr.
Understand.
They are there or not there. How does it matter? Forget that. Yes.
As you lordship pleases.
Yes.
Top item, item 7.
7.
May it please, my lord, I appeal for the petitioner.
Petitioner, right.
I appear for respondents 3 to 7. Lordship.
Appear not for the respondent
8, 10, 9.
8 and 9.
Yes.
Lord, may I file not my opposition Lord,
There was a direction.
Yes, my lord, this is beyond time.
beyond?
Have you got copies of that?
I couldn't, no.
এটা আমি যেটা দিচ্ছি।
No, if you are beyond time, Mr. Kormar, why you are filing today without giving copies to him? Just to delay the matter, maybe.
But these are usual, my lord. He knows, my lord, what we do.
My lord, may I
What is the matter about it?
tell your lordship, my lord? I, however,
Look,
reserve.
Mr. Kormakar, don't file like this. You are quite senior now. You should circulate beforehand so that they can come prepared in the matter. Filing at the last moment without giving copies to them.
He said,
Is there anything material here or usual?
my lord, my apologies, my lord. I am just told that we have received. My lord, we have also prepared a reply. My lord, I am kindly, my lord. pardon-
You don't know that.
I'm sorry. Please don't mind.
You haven't got a copy. You are for which respondent?
Okay, copy this.
3 to
Are you using any opposition to the main writ petition?
Yes, my lord. We have filed our opposition to the main writ petition. We have served also, Lordship.
You are filing a reply to whom? Only to 8 and 9. They have also,
To their,
the others have also filed
my lord,
opposition.
they have, and my lord, to that, I believe, we are not filing a reply. My lord, we'll do it without the reply.
Very well. Let us proceed with the matter.
There is a bit confusion. Lord, the one that has been served, the opposition, is to the main writ petition.
Yes.
Lord, the application I have used the opposition, that is before your lordship. Lord,
What is
that
the
not-
application?
Oh, may I just, my
No,
lord,
there was no direction for filing opposition regarding the application.
I'm told, my lord, the MSTC has used an affidavit to the
To the main writ petition, Lordship. We have filed an affidavit in opposition to the main writ petition, which has been served long back.
oh, no, সেটা
Which is the opposition to the writ petition, Mr. Kormakar filed only that. This one, second one. ফেরত দিয়ে দাও এটা।
তাহলে এইটা-
No opposition to the application. What is the application about?
I'll tell you, my lord. My lord, MSTC, my lord, conducted an e-auction in respect of, my lord, scrap metal. Now, my lord, the client, the petitioner, my lord, before your lordship, my lord, he participated in the e-auction. How did he participate? He, my lord, tendered the bid money which was required, my lord, the earnest money deposit, and, my lord, the e-auction was conducted.
Yes.
Now, my lord, whilst conducting the e-auction, my lord, what happened? My lord, he was intending on bidding for a particular amount, and, my lord, he mistakenly bid a different amount. My lord, good, bad, indifferent, we'll come to the minutes of that later on. I'll tell you, lordship, why the application was filed. Now, my lord, on the very day that the e-auction, my lord, happened, and, my lord, I found out that I had made a mistake. My lord, my bid was put in at around 4:38 p.m., my lord, in the evening. My lord, by 6:30, my lord, I had already sent a mail because, my lord, the portal was not allowing me to, my lord, take back the bid. However, there was, my lord, I believe I'm told there was a tab button or something of the sort. So, my lord, after having received this by mail, my lord, at 10:30 at night, the bid, which was much in excess of what was required to being put in, or, my lord, what my client,
Zero was extra, something like that.
not the zero,
not that
my lord.
matter.
That is what makes it even more difficult.
Yes.
It's not a zero. So, my lord, my client, 10:30, my lord, his bid was accepted, and, my lord, he was told to put in the money in the rest of it, my lord, within a period of 7 days. My lord, he made a representation, not considered. He, my lord, comes before your lordship, my lord, filing an application. My lord, this was done last year, my lord, in October. My lord, it was moved on urgency, my lord, before Honorable Justice Mr. Bhattacharya. And, my lord, he, my lord, took up the matter, but no interim order was granted. In the meantime, what happens, my lord? The money that was being retained by, my lord, MSTC MSTC forwards it to the seller, my lord, despite having knowledge that the matter is pending. My lord, of course, there was no interim order. I understand my learned friends would also
They
say.
wanted you to deposit the wrong, erroneous, that money.
Yes, my lord.
You did deposit that.
No, I did not.
So
I
what
did
did they
not.
forward?
They forwarded the earnest money deposit which was lying with them, my lord.
No,
They forfeited the earnest money deposit which I had put in a sum of 30 lakhs.
The earnest money.
Yes. Now, my lord, that, my lord,
So where was the question of depositing the earnest money? I don't understand this.
my lord,
You
that
have
was
to, you can only put in the earnest money after your bid is accepted first.
no, my lord. The
The bid, you have to deposit the earnest money.
before, my lord, to be eligible. This is like,
that earnest money.
yes, the earnest money. So
That was rightly put in.
that was rightly
That,
put in.
that has now been forwarded by them internally to somebody, to
They
the
have,
seller.
it has been done to the seller. So, my lord, the seller now
Take your seat, I'll hear you.
is, my lord, in, my lord, possession of the money. So this application was taken out, my lord, following a letter which they had sent me saying that we are forfeiting your money and we are forwarding it to the seller. My lord, it is based
What
on
is the writ petition against?
the writ petition is against the forfeiture. So that the money that was put in as earnest money deposit is, my lord, refunded to me. I am not seeking for any interest. I am not seeking for any damages. Nothing.
That is the main conspectus of the writ petition itself.
Yes.
You are wanting back the earnest money.
I want the earnest
Only
money.
that. And what is the application for an interim order to that effect?
Interim order to the effect that the seller be not, my lord, utilize the money or accept the money or take it. My lord, it's in the nature of an injunction application, injuncting.
So what is your argument on this earnest money refund?
No, I believe, my lord, there are two judgments which I will rely on.
Yes.
Kindly bears with me, my lord.
The rest of you, please, you can take your seats. You argue when your turn comes.
May I only indicate something, but before that, might cut short, not the matter. Kindly comes to not page 31.
So what do you want to say? Tell me first.
Not, there's an arbitration clause to the effect.
It will not cut short, Mr. Karma. Take your seat. You address the arbitration point as well.
My lord, I would.
Alternative remedy point as well. Address that.
It's there, my lord.
Yes.
I will, my lord. And if
Fair
this, my
enough,
lord,
he has pointed out prior to your arguments.
my lord, if your lordship is not satisfied with these, my lord, I will definitely, my lord, take your lordship forward. My lord, I am citing, my lord, 2019 SCC online, Punjab and Haryana, pages 119, 1119. Kindly, my lord. My lord, this is also a matter where an e-auction was held.
Yes.
If I may, my lord, place the briefly, my lord, at paragraph 2. Briefly, the case set out by the petitioner is that vide notice dated 5/3/2018, the respondent Food Corporation of India, hereinafter referred to as the FCI, invited financial bids from impaneled bulk consumers, private traders under the open market sales scheme for sale of wheat through e-auction. My lord, 3 lines down, my lord. The petitioner, who is an impaneled trader of the FCI, intended to purchase 1,000 metric tons of wheat stocked at Sunam Center, mentioned at serial number 92 in the list appended at Appendix 1, with notice. Further, in terms of clause 5 of the notice dated 5/3/2018, 10% of the value wheat intended to be purchased at the reserved price was to be deposited as earnest money. Accordingly, the petitioner deposited 20 lakhs in this regard on 7/3/2018. My lord, my lord, my client has also deposited the earnest money deposit required. As indicated above, the online bidding started at 8/3/2018, but mistakenly the petitioner submitted his price bid at rupees 17,900 per quintal. As a result, his bid of 10,000 quintals of wheat swelled to rupees 17 crores 90 lakhs. But immediately, via email dated 8/3/2018 at 11:56, he informed the general manager sales of the FCI that by mistake, he bidded at rupees 17,900 per quintal instead of 1,790 per quintal. And thus he be permitted to rectify his bid, for it was a clerical error. Likewise, by 2 separate emails on 8/3/2018 itself, he also made similar requests to the executive director sales and the chairman FCI. My lord, following this, my client has also, my lord, on the very same day informed.
What were your different quantums? The first bid and the second?
There is no second bid, my lord. The first, that is the only bid that I put in. Instead of 1 lakh 768 rupees, my lord, it has gone to, my lord, 5,768,000 per MT. That is the difference. Anyway, my lord, continuing, in response, the Assistant General Manager forwarded the email to the petitioner to the General Manager FCI headquarter, Delhi, soliciting suitable advice. For as per the tender conditions, there was no provision in the e-auction module to revise the bid. These are, my lord, exactly the points which, my lord, my learned friends are also taking. My lord, they have also said, I could not have revised the bid. I could not have let you downgrade your bid. And if today I allow you to take the money back, it will set a bad precedent. Headquarters soliciting. However, while this was pending, the petitioner was declared winner in the auction, considering his bid value at rupees 17 crores 90,000. Accordingly, by email dated 8/3/2018 at 5:30.
You can come to the last paragraph and the paragraph previous.
The reason why I understand, my lord, it's just rather boring. The reason why I'm placing it, because this is exactly what has happened in my case also.
The reason is only given in the last paragraph, Mr. Dashadigari.
My lord. Expressing in
The only
terms.
ground for the court overturning it. Only ground. It has come to the block bold letter and thereafter.
My lord.
Because we cannot waste much time on these motions.
I will, however, take your
we have
lordship
to
through
strike a
paragraph
balance
8.
between the two.
I will have to take your
You're
lordship
doing justice and injustice to others. Yes.
Paragraph 8. Expressly in terms of the tender notice dated 5/3/2018, the reserve price of wheat was 17,900.
Let us come to the next page, Mr. Dashadigari. Let us come to the
9. Apparently, the authorities failed to
Before
perceive
that,
the matter.
the last sentence of para 8.
There was no provision in the MTF to downward revision of bids.
No,
Correct.
it says the only ground upon which the FCI declined to rectify the error and revise his bid was there was no provision in the MTF for downward revision of bids, which
Correct.
is your case also you're saying.
That is what they have made out, but they have never intimated this to me, my
Your
lord,
case means
after
they
my
have
mail.
also said the same thing.
Yes.
Now 9. 9 is the main paragraph.
Apparently, the authorities failed to perceive the matter from a correct perspective and deal therewith in the right earnest. For this was not a case where the deal therewith in the right earnest. For this was not a case where the petitioner submitted his financial bid preceded by a calculated, conscious decision and then sought to resile to his suitability or requested for downward revision in his price bid. Rather, the situation at hand was where the petitioner actually intended to bid at Atho, but owing to a bona fide error, one extra zero was added to the reserve price. Here, there is no zero. 1 has become 5, admittedly. Neither could the accused of any lapse or willful default or even for breach of any tender condition. Thus, once the authorities were convinced that the petitioner was merely a victim of an accidental omission, it would have been rather expedient in the former had exercised its wisdom and power to set the record straight. We are conscious that at this juncture, the prayer of the petitioner requiring the respondents to revise his bid and consider his claim for reallocation of wheat stocks is not feasible. However, in the given situation, the circumstances, forfeiture of the earnest money, retention thereof, was nothing but unjust enrichment. Thus, we reconsider equitable refund. So, refund was ordered. This is 1. Now, my lord, I will take your lordship to the opposition that they have, my lord, filed. Oh, no, sorry. Opposition cover. Well, this is the opposition on behalf of respondents numbers 3, 4, 5, 6, and 7. Well, kindly takes the bid history, my lord, which they have annexed as R4. Well, that is at, I believe it's not paginated.
Yes, I've got it.
Yes, my lord. Now, my lord, kindly sees right on top, my lord, serial 1.
Yes.
That is, my lord, the petitioner before your lordship, Ali Power Electricals.
Right.
It is, my lord, 5,786,000. And if your lordship, my lord, sees the rest of the bids that have come in, if your lordship takes over the page, it started from 1242. The bid history shows 123, 199. That's how it increases. Ultimately, it goes to, my lord, 1,36,100. The test here is any businessman of common prudence. Would he have bid for this amount? He would not have. That, my lord, is 1. And my lord, he admits that this was a mistake. He also admits that he could have done this. Now, the second judgment which I would want to bring to your lordship's notice, my lord. This is, my lord, excuse me, to 2015 3 LW 125. 2015 3 LW 125. Now I'll take your lordship to, my lord, paragraph 13. This was also where an e-auction was held. This is, my lord, by a division bench of the Madras High Court. Now it says, on the question as to whether mentioning of reserve price or upset price in the auction notice is mandatory, the learned single judge, without there being any pleading, has considered the same and held that the requirement of setting out the upset price is mandatory. Now, the reason why I place this with your lordship is because they have never mentioned any upset price. Or in other terms, my lord, a reserve price which ought to have been mentioned. Having said that, my lord, however, I am not, my lord, challenging the modicum in which, my lord, they have proceeded with the auction. I only want my earnest money back. Now, thus, in the facts of the case where the writ petitioner has not questioned the legality of the proceedings on this ground, we are not inclined to uphold the finding recorded by the learned.
Reserve price is not a valid consideration here.
Ought to have been, my lord, had I been, my lord, challenging, my lord, that is precisely what the judgment says. The
How is
reason
that
why I'm
relevant
taking-
in your case?
I'll tell your lordship.
You have committed an error.
I have committed an error.
You participated in the bid, but committed an error.
I have committed an
Within
error.
2 hours, you tried to rectify that. They did not accept because the time was over.
Yes.
This is the case, entire case.
Yes.
So reserve price being mandatory is not your case at all.
It's not. The reason why I'm demonstrating this before your lordship is only to tell your lordship that I am not challenging the modicum. However, the modicum which by way of which they have conducted the e-auction is perhaps not correct. And my lord, the stage as to where they could say that I am forfeiting your money, that has also not reached, because your lordship is very well aware of the fact that, my lord, an auction is an offer to treat. Now, if it is an offer to treat and I have participated.
What was the relevant provision in the NIT?
In the NIT, I'll tell your lordship, my lord. Petition. The NIT says, my lord, there will be a forfeiture, but then
Forfeiture must be there.
on account of if there is non-payment after being decided as the
Let me
highest
see that
bidder.
forfeiture clause once.
Yes,
Sir,
I'll take your lordship there. My lord, that is at page 37 of my writ petition.
Yes.
My lord, in the middle of the page, I believe it's, my lord.
Yes.
The EMD at 10% is to be submitted within 7 days of closure of e-auction.
So this is page 37.
37.
In the middle of that page.
In the middle of the page, my lord. My lord.
Number.
Under important notes, my lord. My
Important notes, yes.
Yes, my lord. The third paragraph.
Right. Yes.
In case the buyer fails to submit the EMD within this period, he may submit full payment along with taxes within auction. However, in such a, they will remain deactivated. The same shall apply for.
I'm sorry, I can't get it. I mean, important notes. Please note
Yes.
then 1, 2, 3. There are several. Under which serial does it fall?
Oh, no,
If I may just assist your lordship, this particular clause is in page 33, clause 6.1, lordship.
33.
Page 33, clause 6.1, lordship, in the middle. In
Yes,
the
yes.
event of payment on accepted bids not being completed within the time specified, the earnest money in addition to the registration fee shall be forfeited without any further notice to the buyer. This is.
I am grateful to my friend, my lord.
Thank you.
For delay in making payment, the ground rent as mentioned will apply. So, my lord, this stage has not reached, according to me, subject to, my lord, correction by your lordship. And in any event, my lord, If it's a forfeiture, which my learned friend, my lord, is hinting at, my lord, forfeiture in terms of the Contract Act section 73 or 74, whichever my learned friend relies upon, my lord, has to be reasonable, which my lord, they are not demanding. My lord, they want the whole money. I would have understood had they made out a case that this is the quantified amount of damages that I have suffered for this e-auction not going through. That case, my lord, is neither here nor there, has not been made out by anybody. My lord, maybe perhaps a jilt has been made at, yes, I have not received, I believe it was stated as the loss of revenue, but that's only there. There's no quantification as to what is the nature of loss of revenue, whether they have sold it, whether they have held a re-auction. I was willing, my lord. In fact, in my petition, I have also made that submission that if I'm allowed, I could have bought it at 1,62,000 per MT, but my lord, that also has not fallen through. And as far as arbitration is concerned, my lord is aware that, my lord, alternative remedy where, my lord, Article 14 violation and, my lord, others are there.
Please show me the arbitration clause also. Once.
I'll tell you, lordship. Page 30. Page 30.
Yes. Thank you.
Any dispute or difference arising between the seller MSTC and the bidder buyer in connection with interpretation or implementation of terms and conditions shall be referred to sole arbitrator to be appointed. On reference by parties, the provisions of Arbitration and Conciliation Acts as amended shall apply to arbitration. Now, for the arbitration clause also to have, my lord, apply, I would have, my lord, to be contractually bound.
What is the nature of the work intended? I mean, the tender?
Well, this is scrap metal which was being sold.
Could be paid. Yes.
It was one scrap metal which was being sold.
Right. Fair. So this is
So, yes. So I'll take your lordship, my lord, to this which I was pointing out. My lord, the Madras judgment. The offer on a perusal, this is, my lord, at paragraph 14. Your lordship has paragraph 14?
Yes.
On perusal of the chart indicating the bid history, the offer ranges from 1,24,000 to 22,55,848. Thus, the findings of the learned single judge accepting the contention of the writ petitioner that it was a typographical error appears to be correct, as no prudent businessman would offer the amount of bid too high, which may not be the value of the goods. Thus, without going into the question of whether the appellant was entitled to the EMD amount, as it appears to be the case of revocation of offer, and also in view of the fact that the learned counsel for the appellant has not presented the points tenuously, we are of the considered opinion that the writ petitioner is not entitled to any interest on EMD. I am not seeking for interest. I am only seeking refund. Then, my lord, paragraph 15. The action of the appellant in accepting the bid amount of the writ petitioner was also not proper. When the figure quoted was astronomical and certainly much more than the value of the scraps comparing with the amount quoted by other bidders, the appellant ought to have examined the fact as to whether it was a mistake or genuine. In such a situation, the appellant ought not to have acted in haste in accepting the offer and conveying immediately in the late night to the writ petitioner, requiring him to deposit the security money. In this background, it can safely be held that there was a typographical mistake in the amount quoted by the writ petitioner. Thus, both parties were at fault. What is good for the goose is good for the gander. In that event, the appellant cannot be permitted to take advantage of the technicality. Thus, the direction of refund of EMD amount was rational and proper. My lord, I have the trial court judgment for this. My lord, if your lordship wants to refer to the same, I can place it. Resultantly, we hold that the writ petitioner first is not entitled to any interest on the EMD amount, and the appellant shall refund the EMD amount after deducting the expenses incurred by them for conducting fresh auction. My lord, this is as far as this is concerned. Now, my lord, there is a coordinate bench judgment by this court, my lord, if I may place that before your lordship. What about that? Okay. This I have sufficient copies of. Please. Yes, my lord. Paragraph 2. Learned advocate for the petitioner submits that the first respondent is not entitled to forfeit the entire earnest money deposit. The first respondent, having received opportunity to file affidavit, has not disclosed any material to suggest that the respondents have suffered any damage, precisely as the case by my learned friend. Sufferance of damage is a sine qua non for the first respondent to forfeit the earnest money. The first respondent, not having suffered any damage, is not entitled to adjust any amount on account of damage from the earnest money deposit. He submits that the existence of an arbitration clause in the contract does not make a writ petition not maintainable. In support of such contention, he relies upon 2011 5 SCC. One of the judgments which I would also refer to if my learned friend presses that point with regards to arbitration. Relying upon 2016 volume 5 West Bengal Law Reports, Cal, page 67, learned advocate for the petitioner submits that in similar circumstances, the High Court has allowed the writ petition and has quashed the decision of the first respondent not to return earnest money deposit. Consequently, he submits that similar relief should be granted to the petitioners in the present writ petition. Now, my lord, I'll take your lordship to the paragraph 7. The question on which the writ petition was decided, my lord, is at paragraph 4, whether the first respondent entitled to forfeit the earnest money in the factual matrix of the present case is the issue falling for consideration in the present writ petition. My lord, kindly takes paragraph 7. In the facts of the present case, although Coal India Limited has pleaded that it suffered loss and damages by reason of the cancellation of the contract by the petitioner, it has not quantified the loss and damage that it suffered. It is not stated in the affidavit as to what it did with the coal allotted to the petitioner under the subject contract. I pause here for a moment, my lord. Exactly, my lord, what my learned friends have also done. No indication as to what has happened. These facts are material for the purpose of considering the quantum of compensation to be paid to Coal India Limited for the cancellation of contract by the petitioner and the so-called breach of such contract by the petitioner. Moreover, it is the contention of Coal India Limited that the forfeiture happened as and by way of penalty. The word penalty is very wide. It would be harsh to allow Coal India Limited, a public authority, to impose a penalty which is in the nature of punishment on a leading default party to a contract without any loss and damage suffered by such public authority being established, even at a rudimentary level. Paragraph 9. In such circumstances, the forfeiture of earnest money deposit made by Coal India Limited is bad. Such forfeiture is set aside. Coal India Limited is directed to refund the earnest money deposit to the petitioner along with reasonable interest at the rate of 8% per annum on and from the date of the first demand made by the petitioner for demand of earnest money deposit until payment thereof. Now, the only difference between the earlier judgment is here, my lord, no portion of damages has been allowed. In fact, the money has been refunded with, my lord, some interest from the actual date of demand. So, these are the three primary, my lord, points which I am urging. My lord, would your lordship, my lord, want me to address the arbitration clause also, because, my lord,
you have addressed. Yes.
My lord, I am appearing on behalf of MSTC, which was the platform which conducted the sale. My submission, lordship, at the very onset, is the technical way in which these type of auctions are conducted, lordship. For any financial bids to be submitted or any numbers which are put by the bidders, there is a double way, a double protection which is followed. First, they put a particular number which they want, then they are asked to confirm, and they have to reinsert that number in the portal. Over here, lordship, if we look at the difference between the two numbers, my lord, I will just take you to through their writ petition. Para 8 of their petition, they say, para 8, my lord, they say that the petitioner is one of such buyers registered with the respondent number 3, which is me, on paying requisite registration charges. The petitioner has an allotted number. The reason why I'm showing this, my lord, is because this shows that they have bidded in this platform before. They are registered buyers, and there is no case made out from their side that they are not experienced or that they don't know how to submit the bid. That's the first. Second, my lord, is the number. Para 13, lordship, of their writ petition. The two numbers have been put. The petitioners have made a bona fide mistake, and instead of putting in a bid of rupees 161,786, inadvertently submitted a bid of 500,786. My lord, this is not a question of any additional zero, a mistaken number. The numbers are wholly different. One is 161,786 and the other one is 500,786. Twice these two numbers were put in. This is the first case, Lordship. The second, in para 11, they have themselves admitted that there is no option available to the respondent number 3 or even the respondent number 8 to forfeit the EMD deposited by the bidders, save and except when the highest bidder fails and or defaults in making good its bid offer. They had twice put in 500, confirmed it, and then, my lord, they refused to honor the bid. Now, Lordship, I will take you to page 32, Lordship. If Lordship can please come to page 32, Lordship. Clause 3.4.
Yes.
Clause 3.4, Lordship, a bid once given cannot be retracted. As an e-auctioning platform, Lordship, once the bid goes live, once the system goes live, I cannot tamper with it, nor can I change it. They are saying that they have sent me an email at 10:30 p.m. that night.
6:30.
The bid closed at 16:56, as is apparent from the bid history. I cannot make any change once the bid goes live. So as a platform, Lordship, I cannot do anything.
So they sent you an email at 6:30.
6:30, the Lordship, but the bid closed at 16:56, as is apparent from the bid history. Once the bid goes live, I cannot change anything. I cannot tamper with the bidding system because there are other bidders coming in. And as I pointed out, Lordship, it was put in twice. It was put in once, confirmed. This is the technical aspect, Lordship. Secondly, Lordship, they have said page 18, para 33 of their writ petition. They have said the respondents have not replied to any of the representations made by the petitioner, and for reason of the same, the petitioner is unaware as to the present situation of funds or which of the respondent entities is holding on to it or has usurped it. Lordship, they have not disclosed our reply, which we have put in the last 2 pages of our affidavit of reply, Lordship.
That forms part of the plan application, my lord. Because that
yes,
case that we
let him
deleted,
complete, please.
my lord.
So, Lordship, over here, I'm under instruction that we are not holding the EMD. The EMD is with the seller.
You have forwarded to the seller. That he started with that, Mr.
So
Adhikar.
we
That's
have-
why he started with that.
The EMD is with the seller now, Lordship. As a platform, my submission is that if this type of this is not a bona fide mistake. That's point number 1. Because they have put in once, checked it twice. Next, the numbers are wholly different. 161 and 500. It cannot be the same. And third, if this thing is allowed, my lord, we apprehend that this will open a floodgate of litigations against us. Because as an e-auctioning platform, we have given the technical platform. We have done our checks and balances. They have registered with us. They are aware of such checks and balances. Now, my lord, we are not even responsible. We are not holding the EMD. The EMD is with the seller.
Yes.
So, my lord, my limited point on submissions on behalf of MSTC is that MSTC, that is the e-auctioning platform, has done all its diligences, has conducted its technical auction, and there is no mistake and or technical error on behalf of MSTC. We have forfeited, the respondents have forfeited on the basis of a clause which they have agreed into. Now, my lord, the judgments which they have placed, the first judgment in my respectful submission will not apply to the facts of the case because the 2 numbers are totally different. There is no question of an extra zero or anything. A clerical error does not mean that instead of 1,61,000, someone puts in a 5 lakhs. So, as my learned friend was constantly arguing on the point of prudent businessman, lordship, the 5 lakhs has been put in my respectful submission after duly considering and after checking, he has confirmed it. That's the first leg, lordship. Second, Lordship, regarding the damages that I believe the seller will address, but we have also conducted the auction and we have undergone expenses for conducting such auction. But Lordship, the question is of a much larger fact and issue. It is not one individual auction and the costs or damages associated with it. It is the question of the hundreds of auctions which takes place on my platform. Today, if someone puts in a 5 lakh bid instead of a 1 lakh, and then after 2 hours or 3 hours realizes that no, I have submitted a wrong bid and asks me to refund the EMD, then my lord, this will open a floodgate of litigations in which any person, after the bids are closed, they will come back to me and say, no, I've submitted a wrong bid based on bona fide mistake. So my lord, my respectful submission is the question of bona fide mistake should be considered in the light of the bid which has been submitted. My learned friend has shown the bid history. The bid history has been disclosed by us in the affidavit in opposition. This bid history shows the way in which the bid was conducted. The fact that they have put in 5 lakhs, they must have considered, and that is why they had put in that 5 lakh bid.
That you have submitted. Well, let me hear the 8 response. You are the seller.
But the first issue, the base blood of the
Please
claim-
take the microphone. Yes.
Lord, the base claim of Lord, the writ petitioner is on mistake. Lord, kindly considers Lord, section 20 to 22 of the Indian Contract Act once.
What
Lord,
does it say, Mr.
Till what pedestal, Lord, the ground of mistake can be taken. Lord, may I, Lord, hand over a
অরিত্র দাও কন্ট্রাক্ট একটা দেখো আছে কি না কন্ট্রাক্ট তো আমাদেরই আছে তো দেখো বসে আছো কেন তো বলে দেওয়ার কি আছে প্রত্যেকবার বলে দিতে হবে এই তো কন্ট্রাক্ট রয়েছে এটা ফেরত দাও
আছে কন্ট্রাক্ট আছে
বসে থাকো section 20 yes
Lord, agreement void where both parties are under mistake as to matter of fact. Lord, here that's not the case. 21, effect of mistake as to law, that is also not the case. Kindly turns over page 22, contract caused by mistake of one party as a matter of fact, that is the case. A contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to the matter of fact. Similar, the basis of the entire writ petition is barred under section 22 of the Indian Contract Act. They cannot raise today come and say that I am in a mistake. That's why kindly cancel the contract and return the whatever money I have deposited. That's my first submission. The second aspect of the matter is, Lord, kindly considers this kind of tender issues. Lord, previously, the secret envelope had to be forwarded, and now it is over the net. The entire India, whoever is participating in the process, is seeing it. Now, Lord, once the tender opens and the bids are declared, successful bidders are declared, Lord, the price is declared to the entire India. This is, Lord, with respect to Panther conductor scrap materials to be, Lord, sold out. So, Lord, this is also a revenue generation for our concern. Lord, once the bid is open and people know that this is the amount till which the second bidder had conducted the bid and the first bidder, the successful bidder had succeeded in the bid, I will never get in the second tender when I float it, if at all, I'll never get that price at all. This can always operate as a cartel. Lord, the manner in which the writ petition has been framed kindly considers this issue.
But they wrote at 6:30 when the tender had not, the bid had not been opened. It was not published in the
the entire Lord, intention of the writ petition is to render the entire tender process as infructuous.
When was the tender opened? I mean, not
The tender was
not
opened
before 10:30 that evening.
at
Could not have been.
10,
Must have been the next day.
10:30. Yes,
Must have been the next day. Yes.
10:30.
So at the point of time when they sought to rectify the mistake, but it was accepted on the end of either them or you, at that point of time, nobody could have been aware of what have been bid.
Lord, the bid was made already. Here is a situation.
It was undoubtedly made. Yes.
Lord, here,
And he said
this-
twice they had a
Yes, this
chance.
mistake, Lord, what is also been sought to be, Lord, argued by the writ petitioner, Lord, that has been clearly, Lord,
So that is a different
MSTC
aspect
has
of the
been
matter.
has cleared
You
that.
have to overcome two things, Mr. Kormokar. First is that how can you be unduly enriched? Justice Bosak's judgment. The third one, you have to satisfy me on that first.
Question,
Let us proceed
the
with that.
question of undue enrichment will
You have to
come.
show your damages.
Yes, no, the question of undue enrichment and my damages has to be assessed by way of evidence. That's it. That is
So,
not perhaps.
The
not
onus
part-
lies on you because you are withholding the money here.
Yes.
They are saying that because there is no damage. They cannot prove a negative. You are saying you have to say as per Justice Bosak's judgment.
I have to assert.
You have to assert it.
I have to assert.
And
Lord,
prove.
Whatever I assert, I have to prove that
Here
also
you have
by
not
evidence.
asserted anything
Because,
regarding your
Lord, today,
damage.
whatever I assert, say I assert Lord 25 lakhs, 30 lakhs, because whatever the range of Lord the EMD is, beyond that, Lord, I cannot put my.
Once you
petition of
assert,
damage.
Mr. Kormokar, you may say it goes to the into the domain of the arbitration or whatever else.
My
I mean, it's a factual dispute.
My-
You have not asserted here. Not now. I mean, at the relevant point, not at no relevant point of time have you asserted.
Lord, my submission will be
Till now.
my submission will be the basis of Lord keeping an EMD and as a security for forfeiture. If there was no forfeiture clause, the basis is Lord that I have assessed the damages of the entire process to be 30 lakhs. Kindly considers Lord the term of Lord the forfeiture clause once
Yes,
again.
yes.
6.1 Lord
Right.
33. In case of lots where bids have been kept open for the decision of the higher authority of the principal or owner of the material at later date, the buyer will have to pay the earnest money at 10% of the value.
Is this applicable at all in this
Yes.
case?
The date of acceptance of bid. Lord, kindly got it? Lord?
Date of acceptance of bid where?
Lord,
Yes,
fifth
got
line,
it.
fifth line. The date of acceptance of bid will be the date on which the principal sends the acceptance message to the buyer. Here, Lord, declaration is done. In the event of payment of accepted bids not being completed within the specified, the earnest money in addition to the registration fee shall be forfeited without any further notice to the buyer. For delay in making payment, the ground rent such and such, Lord, these are not relevant. So, Lord, the forfeiture clause, you participate in a tender process with this Lord clause there with your open eyes. I say, Lord, this is my right. This right cannot be curtailed. Might be assessed. The assessment, subject to correction, Lord, the writ court will not get into. This is my right given in the terms of contract. And the writ petitioners entered into the contract with open eyes, knowing fully well what are the consequences if I don't do this. Lord, kindly imagine the situation. Today, anyone will come and bid, and tomorrow will say, oh, I have done a mistake. That is perhaps not what the intention of the legislature or the judiciary is in any of the tender matters. Not only floodgate, the entire system of tender will take a backseat. If this kind of litigations are entertained even.
How do you overcome Justice Bosak's proposition? That specifically I am bound with it. Please come to the last judgment cited by Mr.
Yes,
Dasadikari.
yes.
And particularly paragraph 7 of that. That proposition has been laid down as a proposition of law. Ratio has been decided on that.
Lord, here the basis was that the first respondent not having suffered, paragraph 2. The first respondent not having suffered any damage is not entitled to adjust any amount of on account of damage from the earnest money deposit. Lord, here, Lord, I will make this submission, Lord. Whenever, Lord, a tender process is floated, it cannot be said that, Lord, the damage is not apparent. Lord, in my case, I have demonstrated before your Lordship, Lord, the manner in which I will suffer damage. Because I will not get the revenue that I would have got if this tender would have, Lord, been successful. First. Second aspect of the matter is, this is not such kind of a tender where, Lord, the situation is of H1, H2 or L1, L2, where if the first bidder goes or successful bidder goes, the second one comes in. This is not such kind of a tender, my lord. the entire tender has to be scrapped. It is scrapped rather. And the scrapped materials have already also deteriorated during this time, further deteriorated. So that will not fetch me that value. Who will assess that damage, my lord? May I ask this question to myself? Simply, here the question was with subject to correction with coal blocks. In coal blocks, there cannot be, subject to correction cannot be degradation. I understand what, with my limited knowledge, the coal blocks, the older they are, the better they get. So, the damage in Coal India case perhaps is different from what is in our case today. We are dealing in scrap materials. Every day it deteriorates. This is one aspect of the matter. The other aspects, these are my principal two submissions, The other aspects are, this assessment has to be made through arbitration, because it has to be.
That is always there.
Yes.
You have taken
And
that is
for implementation of the terms, your lordship has seen the arbitration clause. May I point out once again?
No.
Very well.
Same.
The last ground is with respect to, I am a government company. I am not a Article 12 authority. I am not discharging any public function. Neither I am statutorily obliged to hold a tender or to float a tender. So, there is no public law element involved. And that's the reason why, no mandamus is maintainable. This is my last submission, if your lordship.
You are a private company.
I'm a government company, but not an Article 12 authority.
Sufficient. No, sufficient for Article 12. Anyway, so these are yes.
Fine.
Reply short.
No, my lord. In fact, I would, my lord, want to revert back to a certain few submissions which is made, my lord.
One I missed out the last one, 2015 3 LW that was cited.
Yes.
There your lordship would find a paragraph which says both parties were at mistake.
Both parties were
Both parties were at mistake.
made a mistake.
Made a mistake.
So section 23
Yes.
as opposed to section 22. Right.
And
Yes, my lord, would your lordship, my lord, kindly allows me, my lord, a day's time to
No,
come back
no,
with the
no.
reply.
Complete your arguments now.
But my lord,
No
I
further
would-
time. Please complete your arguments.
because
No,
my
for
lord,
these
one of
matters,
the-
no.
I'll tell your lordship why, my lord.
That will set a bad precedent. No, every matter cannot.
I'll tell your
You
lordship.
have made your arguments. You have made your arguments. Please complete the matter, Mr. Dasodekar. No further time.
But there was one judgment, my lord, which I was relying upon. In fact, today morning also, my lord, it was
You are
exactly
bad, Mr.
counter-
Dasodekar. We cannot wait for you. If you want to complete. Otherwise, I'll pass my judgment right now. I will do that in any event. If you want to argue anything, argue, but otherwise leave it.
Very well. I will take the lordship.
What was your point which you wanted to cite on?
My lord,
You
that
wanted
was-
to revert back on what point? What proposition of law?
My lord, that was, my lord, with respect to, my lord, section 22, my lord. Because there is a judgment by the Supreme Court, my lord, which I, my lord, wanted
That
to rely
says?
upon. Which says, my lord, section 22 or 23 in such cases, my lord, which would not apply because, my lord, the mistake which is being spoken about or which is being, my lord, relied upon here is, my lord, quite a little different to the mistake which is, my lord, there is a hair length worth of a difference between that mistake which is in the Contract Act and the mistake which happens here. Now, my lord, this is, I understand my learned friend has also said that this is not of a small zero. This is not of a small.
So, difference between Contract Act mistake and what mistake? What is your mistake?
My
Why
lord,
does it not fall within the contract?
my lord, the error on the basis of which, my lord, the repetition, my lord, falls.
No, this is not an error on which in the writ petition.
This is not an error of fact or, my lord, this cannot be
Acha.
treated as a mistake of fact or, my lord, a mistake of law.
No, that mistake, section 22 mistake pertains to a mistake not on fact or law relevant to a writ petition. That is prior to a litigation being filed.
My lord,
Regarding a contract caused by mistake. A contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact.
I
It's
am
very
saying
clear.
that stage has not arrived yet. For my learned friend to, my lord, say that,
When does it arrive?
my lord, it would, like I said, my lord, your
In
lordship
your
is
case,
aware.
when would it arrive?
Had my lord, I had not asked for the bid money to be refunded, he had, my lord, adjudged me to be a person who has, my lord, been declared the winner. And my lord, thereafter, I would have said that I cannot lift it up or you give me an extension or the bid was not right. But my lord, my letter intimating the mistake was, my lord, much before he, my lord, confirmed my bid. My lord, that was at 10:30 on the same night. And my mail was, my lord, at 6:30.
So you say section 22 invocation is premature in your case.
Yes.
Good.
That is precisely.
I accept that proposition as an argument, definitely. Yes.
So that, my lord, is one. Now, my lord, as far as the double way protection is concerned, my lord, my learned friend says, my lord, I have experience. I also say I have experience, which is why, my lord, the paragraphs were there.
Yes.
But, my lord, I say I have experience saying that I know how the system works. So the double way protection that he is saying, my lord, it is an error. It has been typed out, my lord. I wouldn't be able to today, my lord, say why. It was not intentional, but the reason why I'm saying this, my lord, is because this is, my lord, dealing with scrap. Your lordship would also consider that this is not something something which, if I were to stall or, my lord, cartelize, which, my lord, my learned friend is also intending it. If that would have been the scenario, scrap is nothing worth, my lord, cartelization. I have shown you the bid history as to what were the sums, what were the monies which were put in.
Scrap is not scrap for everybody. Not for the people buying and selling.
I understand, but my lord would also take the bidding history, my lord, which my learned friend is also relied upon. My lord, it does not go beyond a certain, my lord, amount, and my lord, thereafter the money has been kept. No, my lord, as far as no option to forfeit is concerned, my lord, paragraph 11, my lord, that stage also has not arrived, because, my lord, he says that after the money, after the person, the bid has been confirmed, within 7 days, if it does not pay the money, then in that case, the forfeiture will happen.
Where do you get the 7 days?
My lord, at paragraph, I'm sorry, my lord, page 33. Yes, my lord, clause 6.1, my lord, in middle of the paragraph. In the event of payment on accepted bids not being completed within the time specified, the earnest money in addition to the register will be forfeited without any further notice. Now, my lord, the money to be put in according to their notice.
They get the time specified.
I'll tell you, lordship, my lord. ওই চিঠিটা কোথায় যেটাতে টাইম দেওয়া ছিল 7 দিন সাড়ে 10টা চিঠিটা কোথায় হলো I'm sorry, my lord, kindly bear with me, my lord, for a minute.
In any event, you have not paid, that is not in doubt. Till date, you have not paid the rest of the amount. Why should you?
Page 39. Page 39.
Yes. That is immaterial, because you have, whatever is the time you have not paid, that is not in doubt.
No, but
you have not paid, obviously, for obvious
I have not paid. I have not paid. But
if you paid, what would be the reason to come up before this?
Correct, my lord. But I have not paid. What is
that
what?
is acceptable, yes.
But my lord, it was only my mail. Had my mail been missing, my lord, I possibly would have been out of court today. He says, I cannot tamper with the system. MSTC, my lord, my learned friend says, I cannot tamper with the system. It is not a question of, my lord, the petitioner asking for tampering with the system. This is, my lord, me saying that, yes, the bid has been made. It has been put in. I made a wrong bid. For whatever reason, kindly pay my money back. Despite that, he, my lord, confirms the bid. And my lord, as far as, my lord, Article 12, my lord, a government company is concerned, my lord, they have to, my lord, go.
Article 12, I'm not satisfied with his argument. I'm not satisfied with Mr. Karmakar's argument. So it is Article 12 comes in.
I am obliged, my lord.
Good. Let me pass on.
I think that's what, my lord.
Learned counsel for the petitioner contends that the present writ petition challenges the forfeiture of earnest money deposited by the petitioner in respect of a tender floated by the respondent authorities for the purpose of buying of scrap materials. Full stop, next para. It is contended that the petitioner erroneously submitted a bid of rupees 5,00,786 oblique dash instead of rupees 1,61,786 oblique dash, which was the actual intention. Full stop. Upon the bid being closed prior to 5 p.m. that evening, at at or around 6:30 p.m., the petitioner sent an email asking for a rectification of such inadvertent mistake committed by the petitioner. Full stop. However, subsequently that night, the bid was accepted by the respondent authorities. Full stop. Next para. Subsequently, the petitioner seeking a refund of the earnest money, the same has also not been given back to the petitioner, necessitating the present writ petition. Full stop. It is argued that in similar cases, a coordinate bench of this court as well as other courts have considered the issue as to whether any damages were made out by the respondent authorities for forfeiting the earnest money deposited. Full stop. It is contended that in the absence of any damages being pleaded or shown by the respondents, it was dehors the authority of the respondents to forfeit the earnest money deposited by the petitioner. Full stop. Next para. It is further contended that the mistake was entirely bona fide, which is evidenced from the petitioner's immediate communication to the respondent MSTC, which runs the concerned portal, regarding the rectification, regarding the intended rectification. So next para. It is further argued by the petitioner that no prudent businessman would have given a bid of such an exorbitant amount, which is evident from a comparison with the other bids submitted by other participants in the tender, which is found out from the documents annexed in the affidavit in opposition of MSTC. For next para, learned counsel places reliance on a judgment of a learned single judge of a division bench, of the Punjab and Haryana High Court, reported at 2019 SCC Online P&H 1119. Full stop. In the said case, it is submitted, it was clearly observed that despite there being an error on the part of the bidder, the court observed that the forfeiture of the earnest money and retention thereof was nothing but an unjust enrichment. Full stop. As such, the amount was directed to be refunded. Full stop. Next para. Learned counsel also places reliance on a division bench judgment of the Madras High Court, reported at 2015-3-L W 125, for a similar proposition, where it was also held that no prudent businessman would offer the amount of bid too high, which may not be the value of the goods. Full stop. It is submitted that the same proposition is applicable in the present case as well. Full stop. Next para. Lastly, learned counsel for the petitioner relies on a coordinate bench judgment of this court, where, in a similar context, it was observed that the tender issuing authority had not quantified the loss and damage that it suffered. Full stop. These facts are material, it was observed, for the purpose of considering the quantum of compensation to be paid to the authorities for the cancellation of the contract by the petitioner and the so-called breach of such contract by the petitioner in the said case. Full stop. The learned single judge held that the word within double inverted penalty is very wide, and it would be harsh to allow the Coal India Limited, a public authority, to impose a penalty which is in the nature of punishment on a defaulting party to a contract, comma, without any loss and damage suffered by such public authority being established, comma, even at a rudimentary level. Full stop. Next para. Learned counsel appearing for the MSTC, comma, while controverting the arguments of the petitioner, comma, submits that the modality of submitting bids in the present context is that there is a two-way verification of the bid. Full stop. Next para. Once the bid is initially submitted, comma, there is a procedure for reinsertion of the quantum of the bid. Full stop. It is submitted that the petitioner claims to be a registered buyer and, comma, as such, comma, is obviously acquainted with the modalities of submission of bid. Full stop. Moreover, comma, it is argued that the MSTC, being merely the portal which conducts the e-auctions, comma, did not have any way out, comma, once the bid was verified and submitted. Full stop. Next para. It is contended further by the MSTC that the discrepancy in the alleged intended quantum of the bid amount and the amount actually bid for itself shows that the error could not have been inadvertent. Full stop. Next para. It is submitted that if such an endeavor of bidders are permitted by the courts, comma, it would open a floodgate, comma, which would be detrimental to commercial transactions being conducted in electronic mode. Full stop. Next para. Learned counsel also places reliance on clause 3.4 of the tender document, which provides that a bid, comma, once given, comma, cannot be retracted. Full stop. Next para. Learned counsel appearing for the respondent numbers 8 and 9. Acha na, arekta line add kore din tar age. Learned counsel for the MSTC also argues that the MSTC was merely instrumental in conducting the e-auction and the money in question has been forwarded to the seller. Full stop. As such, comma, in any event, comma, the MSTC cannot have any liability regarding the claim made in the writ petition. Full stop. Next para. Learned counsel appearing for the respondent numbers 8 and 9, comma, the seller, comma, at the outset objects to the maintainability of the writ petition on the ground of availability of an arbitration clause in the tender document. Full stop. It is submitted that the dispute sought to be raised squarely falls within the domain of the arbitration clause and the writ court ought not readily interfere in such a matter. Full stop. Next para. Since learned counsel for the petitioner also placed his arguments on section 22 of the Contract Act 1872, comma, which speaks of a contract being not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact, comma, it is argued that the said contention is fallacious and not applicable in the present case. Full stop. It is argued that there was no bona fide mistake on the part of the petitioner and that the scope of applicability of section 22 is not there in the present case. Full stop. As regards the coordinate bench judgment of this court, comma, learned counsel argues that the factual matrix in the said case was entirely different from the present one and that the transactions contemplated in the tender floated in the case which was decided by the learned single judge was entirely different from the present case, comma, which merely pertains to the purchase and sale of scrap material. Full stop. Next para. Learned counsel also argues that the respondent numbers 8 and 9 do not come within the purview of Article 12 of the Constitution of India, comma, not being the state within the contemplation of the said article. Full stop. The said respondents, comma, it is argued, comma, are merely government companies having autonomy and carrying on their own transactions and business. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the observations made by the learned division benches of the Punjab and Haryana High Court as well as Madras differ on facts from the present case. Full stop. Next para. In the Punjab and Haryana High Court judgment, comma, the difference in question was merely of a zero being misplaced. Full stop. Next para. The only ground on which the error was declined to be rectified and the bid revised was that there was no provision in the MTF for downward revision of bids. Full stop. It was observed by the division bench that the authorities apparently failed to perceive the matter from a correct perspective and deal therewith in the right earnest. Full stop. The correct perspective, double inverted, the correct perspective, as contemplated by the division bench, was set forth thereafter to be that the petitioner submitted his financial bid preceded by a calculated and conscious decision, and then it was not a case that the petitioner had submitted his financial bid preceded by a calculated and conscious decision and then sought to resile to his suitability or requested for downward revision in his price bid. Full stop. Rather, comma, the situation there was where the petitioner actually intended to bid at the rate of rupees 1790 per quintal, but owing to a bona fide error, comma, one extra zero was added to the reserved price. Full stop. In the present case, comma, however, comma, such factual aspect is not applicable at all in view of the stark difference between the two quanta, which is the difference between the the alleged intended bid and the actual bid submitted by the petitioner. Full stop. Next para. Insofar as the Madras High Court judgment is concerned, comma, there the perusal of the court reveals that the offer ranged between rupees 1,24,000 to rupees 22,55,848. Full stop. The findings of the single judge accepting the contention of the writ petitioner that it was typographical mistake was held to be correct, as no prudent businessman would offer the amount of bid too high, comma, which may not be the value of goods. Full stop. The court further observed that, comma, without going into the question as to whether the appellant was entitled to the EMD amount, as it appeared to be the case of revocation of offer, and also in view of the fact that the learned counsel for the appellant had not pressed the point strenuously, comma, the court was of the considered opinion that the writ petitioner was not entitled to any interest on the EMD. Full stop. The action of the appellant therein in accepting the bid amount of the writ petitioner was held not to be proper, since the figure quoted was astronomical and certainly much more than the value of the scraps, comparing with the amount quoted by the other bidders. Full stop. Next para. In the said case, comma, the offer actually given by the petitioner was of rupees 1,24,22,002, which was held to be astronomical and accordingly a typographical mistake. Full stop. It was, comma, in such context, comma, observed that the offer ranged as per the bid history from rupees 1,24,000 to rupees 22,55,848. Full stop. Hence, the difference between the highest offer than the petitioner was in real sense, astronomical. Full stop. Whereas the highest offer otherwise was rupees 22,55,848, the petitioner had erroneously made an offer of rupees 1,24,22,002 oblique dash. Full stop. However, the difference between the alleged intended bid and the actual bid submitted is of 4 lakh, which cannot by any stretch of imagination can be said to be so astronomical that it shocks the conscience of the court as it did regarding the Madras High Court matter. Full stop. Next para. Lastly, coming to the judgment of the learned single judge of this court in Sri Coal Enterprise Supra, respondent numbers 8 and 9 are justified in arguing that the fact situation therein was different from the present case. Full stop. In the present case, the tender related to purchase of scrap material. Full stop. As opposed to the same, in the case before the learned coordinate bench, it was observed that the first petitioner participated in an auction undertaken by the first respondent and was the successful bidder. Full stop. Upon being so successful, the first petitioner was allowed 1 rake coal in such e-auction at the bid price as specified therein. The e-auction was held in terms of the spot e-auction scheme 2007. Full stop. Thereafter, the first petitioner deposited the entire value of the coal on May 5, 2008 with the first respondent. Full stop. Thereafter, the first petitioner took steps for receiving the delivery of the coal. Full stop. The Indian Railway authorities sanctioned movement of the rake to the destination station at Shambhupura within bracket Rajasthan. Full stop. Thereafter, the first petitioner cancelled the initial destination station for another destination. Full stop. The railway authorities, however, did not provide the rake for the new destination. Full stop. The new purchaser informed the first petitioner that it would cancel the purchase order. Full stop. In such circumstance, the first petitioner wrote to the railway authorities and the first respondent that in the event the change of destination station was not permissible, the order should be cancelled and the entire earnest money deposited should be refunded. Full stop. In such circumstances, the first respondent refused to release the earnest money deposit. Full stop. Next para. The learned single judge, in the facts of the said case, observed in paragraph number 7 thereof that although Coal India Limited had pleaded that it suffered loss and damages by reason of the cancellation of the contract by the petitioner, it had not quantified the loss and damage that it suffered. Full stop. It had not stated in the affidavit as to what it did with the coal allotted to the petitioner, under the subject contract. Full stop. Those facts were held to be material for the purpose of considering the quantum of compensation to be paid to Coal India Limited for the cancellation of the contract by the petitioner. Full stop. Next para. However, the present facts are entirely different. Full stop. In the judgment cited, as discussed above, the transactions had reached a more matured stage where the contract had been initially entered into, but one of the parties subsequently resigned on an extraneous circumstance that the railway authorities did not afford a change of destination station. Full stop. Moreover, in the said case, the Coal India Limited, in its affidavit, had asserted clearly that it had suffered loss and damages by reason of the cancellation of the contract cancellation of the contract italics, cancellation of the contract by the petitioner, but had not quantified the loss and damage. Full stop. The very premise of withholding refund in the said case was apparently the loss and damage suffered by the Coal India Limited, which was not established in any manner, comma, that too, comma, at a subsequent stage than the present case, comma, where the cancellation, the contract itself was cancelled by the petitioner. Full stop. Next para. In the present case, however, comma, the forfeiture clause stipulates a scenario which has not yet reached the stage of entering into a contract, but is penal to the extent that chance-seekers are deterred, DETERRED, from submitting speculative bids. Full stop. Next para. The implicit justification of the forfeiture in the present case is in the action of the petitioner in participating in the bidding process, but thereafter deciding not to complete the process by putting in the rest of the amount. Full stop. Next para. However, comma, we ought not to be so harsh on the petitioner so as to say that the petitioner in the present case was merely a chance seeker. Full stop. Next para. The petitioner, comma, in fact, comma, fairly close to the time when the bids were closed, comma, at around 6:30 p.m. in the evening, at around 6:30 p.m. in the same evening, comma, had approached the authorities by showing their bona fides to the extent that they sought a rectification of the bid. Full stop. In spite of such approach by the petitioner, comma, the bid was treated to be accepted, and the petitioner was charged with non-refund due to having failed on the test stipulated in the forfeiture clause. Full stop. Next para. A perusal of the forfeiture clause is necessary in such context, comma, full stop. Clause 6.1 of the tender document provides, comma, inter alia, comma, that on final approval, comma, the payment of balance sale value will have to be made in the same procedure as in clauses 5.2 A to F. Full stop. In the event of payment on accepted bids not being completed within the time specified, comma, the earnest money in addition to the registration fee was to be forfeited without any further notice to the buyer. Full stop. Next para. In case the earnest money as mentioned above was not deposited within the time specified, comma, it was also observed that the registration fee would be forfeited without any further notice. Where the bids are not accepted finally, the earnest money deposit by the bidder shall be refunded to the buyer. Full stop. Hence, comma, a perusal of the said clause shows that the same does not provide a complete closure, CLOSURE, to the prospect of refund. Full stop. In case where earnest money is not deposited within time specified and the registration fee was to be forfeited without any further notice, where the bids are not accepted finally, comma, the earnest money deposit by the bidder was to be refunded by the buyer even as per the said clause. Full stop. In the present case, comma, however, comma, such stage has not arrived, and the respondents rely on the petitioner having not paid, not completed the procedure even after acceptance of the bid. Full stop. Next para. The bona fides of the petitioner may definitely be in question, comma, since the gross difference between the quantum which was allegedly sought to be bid, that is rupees 1,61,786, and the actual bid amount of rupees 5,00,786 oblique dash cannot be said to be a bona fide error. Full stop. Next para. As such, comma, although the petitioner sought a rectification during the same evening and cannot be said to be a mere chance seeker or speculator, comma. In the facts of the present case, comma, the error of the petitioner could not have been said to be bona fide under any stretch of imagination. Full stop. The matter, comma, unlike the other cases cited, comma, was not merely restricted to a misplacement or addition of a zero. Full stop. It was also not a case where one of the digits, comma, either in the uh, uh, one of the digits in the quantum sought to be bid was erroneously mentioned. Full stop. Here, the entire quanta are different from each other beyond recognition. Full stop. Next para. However, comma, the quantum actually bid is not so exorbitant or astronomical as to come within the purview of the judgment of the Madras High Court cited by the petitioner. Full stop. Hence, comma, the petitioner could not be said to have made a bona fide error. Full stop. The initial bid submitted by the petitioner appears from the quantum to be a conscious submission of bid, which was sought subsequently to be rectified by the petitioner. Full stop. Next para. Clause 3.4, comma, as rightly pointed out by the MSTC, comma, forbids a bid, comma, once given, comma, from being retracted. Full stop. The petitioner in the present case might have had a second thought, but has to be deterred from undertaking an exercise from altering its bid after the stipulated time of closure of bid was over. Full stop. It is rightly contended by the respondents that if such an effort is given a premium by the courts of law, comma, a floodgate will be opened and the entire sanctity of the bidding process and the closure time would lose relevance. Full stop. Next para. That apart, comma, in the present case, comma, the petitioner has experience in the field of such bidding and commercial transactions as per admission made by the petitioner. Full stop. Next para. The bidding process involves a double check, comma, insofar as the bid amount is to be reinserted by the bidder. Full stop. Having availed of such opportunity and procedure, comma, the petitioner cannot subsequently resile after the stipulated period of closure of the bid and come back to retract from its original bid and rectify the same. Full stop. Hence, comma, on terms, comma, the provisions of clause 6.1 are applicable insofar as the payment of the bid was accepted but not completed by the petitioner. Full stop. Hence, comma, in view of the above discussions, comma, na arekta line add kore din, as to the argument of availability of arbitration before the petitioner, comma, the same cannot be said to be an absolute bar, since the petitioner, comma, in the present case, comma, has challenged the very principles of imposition of non-refund and forfeiture by the respondents, comma, which exceeds the scope of arbitration as contemplated in the arbitration clause in the tender document. Full stop. Next para. As far as Article 12 of the Constitution is concerned, comma, the respondents' authorities definitely come within the purview of the same. Full stop. Apart from being government companies, comma, the respondent numbers 8 and 9 conduct business as a public forum on a public portal, and as such, comma, there is an element of public law interest, public law involved in the present case. Full stop. Hence, comma, such grounds of maintainability cannot but be turned down. Full stop. In the facts of the case, comma, however, comma, the petitioner is not entitled to refund within the purview of the terms of the tender document. Accordingly, WPA 22214 of 2022 is dismissed on contest without any order as to cost. প্রথম লাইনে লিখে দেবেন affidavit in opposition and reply. Affidavit in opposition filed by the respondent numbers 8 and 9 and the reply thereto filed by the petitioner today be kept on record. Sorry, Mr. Dasodikari, well argued, but yes. Acha, can one of such and such is accordingly disposed of as well. I'll come back for the next matter after 10.
8.
May it please your lord.
Yes. Yes.
My lord, before I say anything, my lord, I tender unqualified apology, my lord, for not being able to be present yesterday.
Yes.
Now, I will begin the matter not by inviting your lordship's kind attention to the order dated, 12th December 2022, passed in the proceedings. Lord, this order is an elaborate order, my lord, and it records, my lord, everything concerning the matter, and that exactly is my case. My lord, we are contractors appointed by, at the outset, I am seeking your lordship's leave to file the reply to the supplementary affidavit in opposition. Now, the writ petitioners are labor contractors executing jobs for the West Bengal State Electricity. The present writ petition has been filed challenging office orders dated Saranjat. The first impugned order dated May 1713, annexed at page 42, contains revised rates and conditions and rate contract. In clause 8, it is 8.10, it is stipulated that in case of accident while working on the system of SEDCL, if it is observed that the contractor's laborers had no personal protective equipment and other safety standards were not observed, due to which accidents occurred, the order of the concerned contractor shall be cancelled immediately, in addition to other actions, including prosecution under the penal code that the contractor is legally liable for. Clause 8.11 provides if the contract laborer meets an accident while working on the system resulting in death or loss of earning capacity of the labor, his legal right concerned labor in case of loss of earning capacity shall be entitled to compensation as per Employees Compensation Act, and such compensation shall be recovered from the contractor. The next order is May 12, 17, page 44, provides guidelines for imposition of penal measures against defaulter, official, outsourced agency for erection in case of occurrence of any fatal accident due to improper shutdown. In the said order, it is inter alia observed that if it is inter alia provided that if it is observed that the outsourced agency had undertaken the erection maintenance job in absence of proper supervisory personnel at work site without conforming proper shutdown in respect of the exact line, feeder, etc., or PPE or execution of the job without informing the controlling officer in terms of the LOA, it shall be immediately placed under the holiday listing. The third order, dated July 28, 22, concerns administrative action against contractors in case of fatal work accidents and pertain primarily to withholding new job orders to the agency as per approved rate contract if in her labor meets with fatal accident until the findings of the permanent inquiry committee as per prevailing rules. Such temporary debarment shall continue until inquiry proceedings and subsequent actions are complied with. The said order also casts liability on the contractors to be watchful enough to ensure compliance by the laborers, cover topics such as the usage of PPEs, taking proper shutdown measures, and observing safety measures. The guidelines dated March 26, 2008, that is page 71 of the affidavit in opposition. My lord, can kindly mark it. The petitioner's reply is a circular issued by the SEDCL demarcating the liabilities and responsibilities of the concerned officials of the SEDCL. The same casts several responsibilities on the said officials with regard to violation of labor laws and extension of rightful legal dues without deviation of part-time laborers engaged by the SEDCL. The controlling officer has been conferred the responsibility to forthwith initiate penal action against the persons found responsible for negligence, dereliction of duty, and unlawful action and blacklisting of the contractor alleged concern. Then, my lord has been kind enough to record the submissions of the parties. Please now come to internal page 7 of the order.
internal page 6. My lord, it begins, the paragraph begins. My lord will not have the this downloaded copy. Upon hearing learned counsel, a perusal of the annexures to the writ petition, it is seen that there is an ongoing dispute between SCDCL and the contractors with regard to limits of their respective responsibilities with regard to safety and security and performance of the works. Since several meetings were held between the SCDCL officials and office bearers of the contractors associations, it was recorded in the minutes of October 5, 2018, between two groups that a committee would be formed involving persons to look into the grievances of the contractors and to come with a definite recommendation in respect of the issues involved with regard to the workers' compensation. Till the time that the committee submits its report, which was to be done by November 30, 2018, no new proceeding as per provision for violation of safety referred to in May 12, 2017 was to be initiated against any contractor. However, the report of the said committee has not yet come, much exceeding the stipulated deadline of November 30, 2018. Since negotiations are going on, it can be deemed that the understanding between the officials of the SCDCL and the contractors with regard to no new proceeding being initiated for violation of safety as per office order dated it would stand valid. The petitioners have also made out a prima facie case with regard to there being discrepancies and inherent contradictions in the office orders themselves. In the order dated May 17, 13, it was stipulated that it shall be the personal responsibility of the officer who is awarded the order that adequate PPEs are available with the contractor and no labor is allowed to undertake any job without informing the concerned officer and without observing the safety standards of the company. If it was observed that the contractors, laborers had no PPEs and other safety standards were not observed, due to which accident occurred, in that event, the order of the concerned contractor shall be cancelled immediately in addition to other actions, including prosecution under the penal code. In the office order dated May 12, 17, the responsibility has been given to the officer who allows the task for undertaking any erection or maintenance job to any outsourced agency that requires shutdown. The particular assigned employee of SCDCL responsible for shutting the system down, including issuance of permit to work card, field memo, as the case may be, as designated by the officer, must be physically present at work site for completion of the job. For failure to shut down the exact line, feeder, such and such, and occurrence of any fatal accident, the employees concerned is to be immediately placed under suspension pending inquiry, institution of departmental proceedings by the divisional manager. However, in the same office order, it is provided that if the agency had undertaken the erection maintenance job in absence of proper supervisory personnel, without conforming to proper shutdown, non-use, non-availability of proper PPEs or execution of the job without informing the controlling supervising officer, it shall be placed immediately under holiday listing. The said terms, now this is important, are patently contradictory, at least on a prima facie assessment, since in the same breath, responsibility has been cast upon the officials and employees of the SCDCL to undertake supervision of the workers, whereas responsibility is again shifted to the contractors for non-compliance of safety measures and improper shutdown of the works. This merges the boundary between areas of responsibility of the SCDCL and the contractor. Moreover, the apparent work assigned to the contractors is to provide workmen and mobile vans sufficiently equipped for the shifts in question and to provide adequate safety gear to the workmen for the job at hand. However, once the work begins at the work site, the supervisory role is vested in the SCDCL personnel, who are naturally technically more equipped to look after the work. Insofar as the shutdown of the system is concerned, it is evidently a technical job to be supervised by the SCDCL personnel and cannot be left at the mercy of the contractors, particularly since the latter are not charged of the supervision. The Contract Labour Act is the relevant act governing the circumstances of the present case. The scheme of the act, in particular, as reflected in the definition of contractor in section such and such, which governs licensing of contractors, in chapter 5 providing the welfare and health of contract labor, clearly indicates that primary incidence of liability for the safety and health of the labor force lies on the contractor. If the contractor fails in his duty, only then the liability shifts to the principal employer. However, there cannot be any blanket proposition that a contractor in every case is liable for execution of the entire work, particularly of a technical nature such as the maintenance of electricity lines. A perusal of the communications between the parties and the minutes of the meetings as discussed above show that the contractor's responsibilities up to providing a fully equipped mobile van and laborers with full safety gear. The guidelines dated of March 26, 2008 of the SEDCL itself provide, framed in the presence of the manager and managing director of the SEDCL, clearly cast serious responsibility on the concerned officers who are in charge of the works in question to ensure that the safety measures are fully implemented. The moment the contractor supplies the labor force with adequate safety equipment and sends a mobile van also duly equipped, the liability of the contractor apparently ends and the supervisory capacity of the officers of the SEDCL take over. There are definitely some discrepancies inherent in the various office orders issued by the officials of the SEDCL, particularly the Director of Human Resources. However, the petitioners have made out a prima facie case as to whether such office orders issued by individual officials who may themselves be responsible for the welfare of the laborers can contravene the circular dated March 26, 2008, issued by the SEDCL in presence of the chairman and managing director. Hence, the petitioners have made out a prima facie case for the writ petition to be heard on its merits, accordingly such and such, till February 28 or until further orders there shall be. But this interim order is today subsisting. Now, my first submission to your Lordship, as we have learned, this order was not carried in appeal. There was no intra-court mandamus appeal preferred from this order. The prima facie findings, apparently, is also to be taken into judicious consideration as at the time of final hearing of the matter. Now, they have used an affidavit to the principal writ petition disclosing as to what prompted them to issue the relevant circulars. But before that, I invite your Lordship's kind attention to a comparison, between the relevant circulars. Now, please see. There are four apparent total.
You have given a copy.
I'll just add a copy this. Sir, can I copy this? দেওয়া হয়েছে মনে হচ্ছে আমাকে দেওয়া হয়েছে এই কম্পারিজনটা
Yes, what are the differences?
প্লিজ স্যার এইটা এখান থেকে একটু দেখুন আমি আপনাকে বলে দিচ্ছি এখানে তিনটে আছে 26 March 2008 বাকি তিনটে আছে in the first circular kindly see 26 March 2008, that is page 71.
What are you challenging here in the
my principal challenge is this provision in the last circular 28 July 2022. It says it is hereby directed to all the controlling officers not to allot any new job order to the agency as per approved rate contract if any of her labor meets with fatal accident until the findings of the permanent inquiry committee. And it also envisages blacklisting. It also envisages that this contractor shall thenceforth on the event of an accident taking place, sir, in the event of an accident taking place, they will be, apparently they will be in the holiday listing or whatever, and they will not be awarded any fresh order. Now, the issue which falls on a very narrow compass, it begins from the circular of 2008. Please see in the circular of 2008, which is page 71 of the affidavit in opposition. Now, here it says accidents and payment of compensation to contract laborers as per Workmen's Compensation Act. Contract laborers, if sustained injury in course of and out of engagement work of the company resulting in death or loss earning capacity shall be entitled to compensation as per the Workmen's Compensation Act 1923, and such compensation shall be paid by the respective DDOs of the division through commissioner workmen. Now, this forms, according to me, according to the first order made by your lordship's court, and according to the entire conspectus of the facts, this apparently is the sheet anchor of the entire case, because this circular unequivocally says that a workman or a laborer who is working under a contractor, he will be, in the event of a fatal injury sustained by him, will be entitled to certain benefits. And in my most respectful submission, as has been recorded in the order, the Contract Labor Act also envisaged such a thing. The Workmen's Compensation Act, I will refer to it. It has now been replaced by the Code of Wages Act, 2020. The original Workmen's Compensation Act has been repealed, and there's a new provision, Section 85, in the new Act. Previously, it was Section 12 in the old Act. Code of Social Security Act 2020. It has apparently repealed a number of legislations. Be that as it may, my humble submission to your lordship is, reading the 2008 circular and the last circular, your lordship will apparently find,
Mr. Bhattacharya, while you argue, please ask your the junior most of you just to give a list of the books you want to rely on. This Code of Wages and all these, so that we can.
Code of Wages Act, I think,
Code of Wages, what was there?
because this matter was previously heard at length. We'll give you a lordship a book. We'll give you a lordship a book.
Just give a give a list of the books so that in other matters also we require. So
Code of Security Act, in this ordinary case.
maybe. Just give a list. No, I'm not asking for the book at this stage. I'm asking for a list of the books you want to cite. Yes, let us continue, Mr. Bhattacharya.
Now,
boy list yes.
Now, here, looking at the the subject matter of challenge, we are in the writ petition, we have sought to assail this last decision. We have sought to assail the annexure P11 to the writ petition, which is the 28 July 2022 circular. That is at page 56 perhaps. No, 46. Thank you. The page number, annexure P11. Annexure P11.
56.
Not page 56. I'm sorry. Not administrative action against contractors in case of any fatal accidents. First submission to your lordship is, this is not in continuation to the previous decisions. It is an independent decision of the director, HR. And it says, the recent incidents of electrical accidents have become a great cause of concern to the company management and other stakeholders. Besides the accidents involving general public, many cases of work accidents are happening involving the contract laborers of various agencies. Various safety meetings, seminars, guidelines towards usage of PPEs, taking proper shutdown and observing various safety measures are still unable to accomplish accident-free environment, as those are not being complied by many contract laborers who perform the jobs on daily basis, and concerned contractors, agencies are not being watchful enough to ensure the compliance. Therefore, the accidents at various work sites are going on unabated despite having definitive guidelines towards safety. In view of the above, it is hereby directed to all controlling officers not to allot any new job to the agency as per approved rate contract if any of his labor meets with a fatal accident until the findings of the permanent inquiry committee comes out as per prevailing rules. Such temporary debarment shall continue until inquiry proceedings and subsequent actions are complied with. Now, my lord, an accident necessarily may happen, my lord. This sort of a technical job. It is a job, my lord, ACDCL, as your lordship knows, my lord. My lord, in another matter, my lord, incidentally, I'm appearing for ACDCL. There, the officers are involved. Ordinarily, my lord, these jobs are, my lord, outsourced, and my lord, they invite my lord people to participate in this contract, and my lord, they award the letter of award, and my lord, this sort of contracts are my lord undertaken by specialized contractors who have my lord sufficient my lord work experience for the purpose of my lord this distribution. My lord, yesterday a matter was going on my lord regarding the poll. My lord, a person's my lord, there just prior to my lord my matter being taken up, a gentleman was arguing my lord regarding an electricity poll. My lord, it fell from your lordship that this entire distribution owing to this shifting cannot affect the entire distribution, because this distribution, this line, everything, my lord, it is carried on a very expert basis, and my lord, it is carried on by people who are my lord equipped enough to ensure that the supply is not disturbed. Supply, my lord, in the sense of SEDCL, my lord, SEDCL, the transmission company and the distribution company, my lord, it caters to the entire state of West Bengal apart from CESC dominated areas. Now, my lord, this being the last of the circulars. Now, my lord, the first circular in this regard is annexed at in the main affidavit in opposition.
Page 71.
Page 71.
Yes.
Now, this is circular dated 26 March 2008.
72 and niche date.
And it is memo number 244/8/1081. My lord, if they have disclosed this, my lord, please see page 72.
Yes.
72 and niche date.
Accidents and payment of contract compensation to contract laborers as per Workmen's Compensation Act. Has my lord very kindly got it?
Yes, yes.
My lord, contract laborers if sustain injury in course of, and I read that portion, my lord, before your lordship on the way.
Yes.
Insofar as they work in respect of which no insurance premium against the contract laborers engaged is provision included in the schedule of rates approved by the company, and simultaneously negligence, dereliction of duty, and for any unlawful activity led to an accident, the controlling officer should forthwith initiate penal action against the persons found responsible. Therefore, including drawing up disciplinary proceedings if the person responsible is an employee of the company, and blacklisting the contractor concerned. In addition to the inquiry report of the accident, preliminary, interim, or final indicates criminal responsibility of any of the employees of the company and or concerned contractor, and FIR should be lodged against them by concerning controlling officer with the local police station. It is directed that neither any contract labor will attend any work of the company without having valid work order, etc. I mean, what I am on is here, looking at this 26 March 2008 and reading this with the last one, it appears that the entire burden of this responsibility
cannot be a blanket burden on. You are saying it. There can be an inquiry. Whoever is responsible holding guilty.
But what appears to be is prima facie contractor debarred. Second, it is as if with deepest of respect to your lordship, any person can meet with any accident at any point of time. It may not be, it is his responsibility always. Maybe there may be n number of reasons, for a person meeting with an accident, or a laborer or a contract labor meeting with an accident. But the 2022 decision, it casts, it's a complete deviation from this 2008 decision, and which
it renders the inquiry also redundant.
Yes,
because the entire liability is cast on the contractor.
On the contractor, and as if it is just to say that as if I am not responsible. Because today SEDCL does not have the requisite mechanism to employ so many persons in its regular establishment so as to cater to this supply. So they have to outsource it. They have to do it in a phased manner, and in a manner inviting applications from these contractors, and that is also on the basis of the contractors fulfilling certain criteria, which inter alia include electrical license. It inter alia includes, my lord, some work experience. And, my lord, I have in a very short supplementary affidavit sought to disclose, my lord, the documents, my lord, the first work orders that were issued in my favor.
Mr. Bhattacharya, you are agreeable to this, the first one prevailing?
Yeah,
Because there can be an
2008
No,
thing
sir.
continues, my lord, I have no issues. We have no problem.
Yes, you never challenge this also.
We have, my lord, we have been accepting this position.
Right.
And, my lord, and, my lord, incidentally, there was a subsequent circular of 2010,
Yes.
my lord, which, my lord, in that chart that I have handed over to my lord,
Yes.
28. এটা কি disclosed?
Disclosed.
Yes. Yeah, it is a part of my writ petition.
Give me the page numbers.
I'll just give you a lot.
These
Just
orders. I'll just note on your
give, my lord, I need. Page 38 of my writ petition.
2010.
Yes, 2000, this 28/4/2010.
Yes, page 30.
Page 38 of the writ petition.
Yes. Please give me the page number of
No,
the
no,
others
page
also.
38 of the writ petition,
Yes.
annexure P3.
Give me the number of the page number of the other
17th May 2013
yes.
is, my lord, page 42
Read.
of the writ.
42, 43.
42, 40,
Yes, yes,
whatever, 42, 40.
Copy
Yes.
is at page 27 of the.
And, my lord, it is a better, a more legible copy is at page 27 of the AO.
Yes. And the last one?
And, my lord, the last one, my lord, I invited your lordship's kind attention, my lord, page is 56.
Oh, that one. Oh, this is the impugned one.
Hey, is impugned one.
Yes.
28 July 2022. My lord, a better copy is also there in the affidavit.
Need not.
Now, my lord, please see 28/4/2010, my lord, 8.12. If the contract laborers meet with an accident while working on the system of the company, resulting in death or loss of earning capacity of the labor, his legal heirs concerned labor, in case of loss of earning capacity, shall be entitled to paid by the SADCL to the Commissioner of Workmen's Compensation as per the Act, and such compensation shall be paid by SADCL through Commissioner following the guidelines as per circular dated 26 March 2008 of the Director HR, existing delegation of power for distribution wing shall apply to ascertain the sanctioning authority. Now, my lord, this exactly your lordship will be pleased to find at page 39 of the writ petition. My lord, I do not know whether it is marked copy.
Need not. I understand. Yes.
This is, my lord, the better copy is 27.
Yes, yes.
Now, my lord, this being the position, a labor-friendly mechanism has been sought to be done away with completely, and, my lord, the entire responsibility is now being foisted on the, my lord, the contractor, not as if to suggest that, my lord, the contractor is the only person responsible for any accident under the sun, and their officers, their supervisors, my lord, has been pointed out in the order dated December 2022. This honorable court, my lord, incidentally, it was your lordship, but, my lord, this honorable court was pleased to record that the supervisors have a role in the shutdown. My lord, the company has a role in the shutdown. I cannot, my lord, shut down the system unilaterally.
So you stand by 2008 and 2010 circulars.
Yes.
What about 2013?
My lord, please come. Important issue. That is not a very important issue. Now, my lord, please see the 2013 one.
Yes.
It slightly shifts the burden. My lord, it says, it shall be the personal responsibility of the officer who awarded the order that adequate PPE are available with the contractor and no labor is allowed to undertake any job without informing the concerned officer and without observing the safety standards of the company. In case of accident while working on the system of SETCL, if it is observed that the contract laborers had no personal protective equipment and other safety standards were not observed, and due to which accident occurred, the order of the concerned contractor shall be cancelled immediately, in addition to other actions, including prosecution under the penal code. If the contract laborers meet with an accident while working on the system of the company, resulting in death, loss, etc., shall be entitled to compensation as per the Employees Compensation Act, and that compensation shall be recovered from the contractor. Now, here again, your lordship will find a slight shifting of burden. One. Two is, regarding this inquiry part, it is envisaged in the first circular also.
But you are not challenging this also.
No. Not in the writ petition, the challenge is principally to the 2022.
Right.
And there is annexure P5 to the writ petition. Please come. P5 is at page 44. This is also under challenge. 44
Indemnity bond.
Yes. Please see, I will request my lord to ignore page 44 and kindly marks at page 44, 67 of the affidavit in opposition.
But this is a part of the 2013.
No, 17. This is 17. 12th May 17.
Where do I get the date?
Top.
Page?
Order number 1.
This is page?
Page 67 of the AO and corresponding to 44 of the writ.
Page 67 of the AO, more legible probably. And date is there also at the top.
Oh, I'm sorry, page 67. This, all right, yes. This also you are challenging.
Yes, yes. Regarding, I'm sorry. Please see clause A. Clause A regarding SETCL's official responsibility. Please skip. Please see 1. I'm sorry, not skip. It is the responsibility of the officer who allots the task for undertaking any erection or maintenance job to any departmental employee or outsourced agency that requires shutdown. The particular assigned employee of SETCL responsible for shutting down the system, including issuance of permit to work card, field memo, as the case may be, as designated by the officer, must be physically present at work site till completion of the job. For failure to shut down the exact, etc., your lordship may skip it. Please see 3. In case of any fatal accident owing to improper shutdown, in addition to the concerned employee, the assessing officer in charge of the CC line such and such will also be held responsible and shall prima facie be temporarily debarred from duty at his place of posting till receipt of clearance from the permanent accident committee, completion of departmental proceedings, whichever is earlier. Now, there must be in all these decisions, your lordship is looking at the decisions, the ultimate end decisions. What was the basis? Ordinarily should flow from the affidavit in opposition. Kindly takes the principal affidavit in opposition, paragraph 4.1. I'm sorry.
4.1, yes.
The main object and purpose of issuing office order dated such and such. They also refer to 26 March 2008. They also refer to 17 May 13, 12 May 17, and 28 July 22. We are concerned with these 4. are to ensure the safety of huge pool of contract laborers who are engaged day and night to serve the state under the enlisted contractors. Lack of supervision from the part of the contractors and their supervisors and non-adherence of various safety rules as framed by SCDCL and also under the terms of conditions of the rate contracts are the primary reasons for accident. Then we have two is for safety. The decision is to implement and give effect to this. But this is how they have said. Now we have please see 5 here.
Yes. Do's and don'ts.
Yes. Then 6, according to SADCL in their affidavit, page 5, paragraph 6, Roman 6, the office circular dated 26 March 2008 is basically, according to them, a guideline to enforce various provisions of the Contract Labor Act and the Workmen's Compensation Act, various labor laws, etc. As principal employer, ensure remittance of PF contribution. Then again, 17th May 2013, cited by the petitioner is basically rate contracts for engaging LTHT maintenance mobile van outsourced unskilled with tools, tackles, PPEs under monthly job contract basis. The jobs are allotted to the contractors as bundled contract basis with rates, detailed scope of work, etc. Had this been followed scrupulously, the majority of the accidents could have been avoided. Then 8.10 they refer to in paragraph 9 basically says that the ordering authority must ensure that safety norms are to be followed by the contractor and its laborers. We don't have any quarrel with these things. What
they say at the end of Roman 9, at
my
page
lord,
6.
my lord. Hence, even after describing the required safety norms by the site, that is what my lord is referring to.
Right.
Describing the required safety norms by the site in charge against each of the awarded, if the contract laborers disobeyed that, which is clearly tantamount to a lack of supervision from the part of the contractor and its supervisor.
Denied this. You say there cannot be parallel supervision by both.
The supervisor is their supervisor.
Their supervisor there. Therefore, this sentence is bad. Lack of supervision from the part of the contractor and its supervisor, that is incorrect.
Subject to correction.
Is there any scope of your supervisor being there?
With respect, in the I have, with your lordship's kind leave, affirmed the supplementary affidavit, which has been also, objected to. According to my supplementary affidavit, the supervision part is to be done. There is a dispute here. The dispute is, according to my case, the supervision is the entire burden of the SADCL.
Where do you derive your argument from? I mean, what is the basis of your
because in the opposition to this affirmed on first.
So do you rely on any circular or anything, any law or something?
The work orders that were issued in our favor do not, in my humble understanding, I may be wrong, subject to correction by my esteemed senior, it does not envisage strictly the supervision is to be done by my supervisor.
Show me one of the work orders. What should I look into the supplementary affidavit?
একটা better copy নেই অনিন্দ, এগুলো একটা copy নেই। My lord, in the supplementary affidavit, this is a draft copy of a work order, my lord, of 2022,
These are
which I have annexed.
So these are supplementary affidavit to the affidavit in opposition?
No, supplementary affidavit of my client, my lord.
Yes, yes, right. In the back sheet of Mr. Das.
Yes.
Which page?
My lord, please see 25.
25.
In the clauses, my lord, it begins from page 25(1). This is the draft copy, my lord. It is unfortunately not very.
No, it's all right. Legible.
My lord, a better copy is with me.
No, let me look into this.
My lord, kindly takes this. Kindly takes
So
this.
it's easier to for me to follow.
My lord, kindly, well, I will. I will.
No.
My lord, you take my copy. My lord, take Mr. Das.
Legible.
Oh, acha.
Any speciality in your copy?
No. My lord, I thought, my lord, this was a better copy. Nothing else.
I think this is a much better.
But if you lordship feels so, my lord.
So in this process, you're trying to take away the legible copy from the court and give your illegible copy to the court. I'll remember this while deciding the matter. Yes. Patent lack of bona fides on your part, Mr. Bhatt. Which is the relevant clause? Supervision.
There is no.
Show me your worst clause. I mean, is there anything to which they could argue, preempt their argument?
They may rely on this two: engage, skilled labor, possessing workman, valid permit, etc., and adequate expertise and experience.
That is not
usual clauses.
right.
Materials will at least see maintenance work. All required materials shall be issued by SEDCL on requisition. The clause 6.
So your duty ends up to the gate. I mean, if the laborers come, up to that, they have to be supplied.
Of laborers, we disclose
PP and all the things have to be there.
Our responsibility.
But they have to, after that, their supervision starts.
It is they, because the circular also says so.
Circular also says so, right.
It is gradually from the stage of direct workman's payment to the workers by the SEDCL's end to some role play of the officer, then completely doing away with officers and vesting the responsibility on the inquiry committee, which was existing in 2008 also. I do not mind to that. What I am apprehensive of is today, assuming but any accident which takes place, suddenly I'll be blacklisted. I will be completely debarred. I will be shown the door. No further orders. These sort of penal measures, it affects my business right to work. I am only the supplier of labor, and subject to correction.
So one question to you: you are not challenging 2013 circular, but 2013 circular also carries certain things against you. Like if you come to your comparison chart, that is one other question I want to put.
Yes.
Please come to the comparison chart and just read out the order number 24 dated 17/5/2013.
Yes.
The third column.
My lord.
Just place it, please.
Just.
Yes. Take your time. Just find out the comparison.
2013.
Right.
It says it shall be the personal responsibility of the officer who awarded the contract.
In the first sentence, yes. Then in the next sentence,
are available. Yes.
In case of.
And while working on the system of the SE, if it is observed that the contract laborers had no PPE and other safety standards were not observed and due to which accident occurred, the order of the concerned contractor shall be cancelled immediately in addition to the other actions including prosecution of. This clause to an extent affects you.
It affects you, but is also not challenged by you because it's your responsibility after all to provide them with PPE equipment till they go there.
Yes, 100%. That is my work.
This may be an extension of your duty also. This does not speak about supervision at all.
No.
All right. And 8.11, the next clause?
Yes. If the contract laborers meet an accident while working on the system of the resulting in death, loss, etc., shall be entitled to compensation as per the Act, and as such compensation shall be recovered from the contractor.
You never challenge this also?
No. Principally speaking, looking at the Workmen's Compensation Act also.
Yes, exactly.
There is some mechanism
first
the
incident.
recovery part.
First
Because
incident
Milord, today, kindly visualize, subject to correction, Milord, person covered by the ESI need not, Milord, go to this extent. Because, Milord, ESI Act has a special mechanism to cater to the, Milord, life and livelihood of these persons, Milord, who are the workers there.
But it is nowhere stated here that the supervision has to be under
The supervision thing is their, Milord, invention.
only the.
Why? Because, Milord, they wanted to completely shift the burden on the contractors, as if to suggest that the contractors are personally responsible for any accident. Milord, someone high on the top of the pole, if the, Milord, ladder, Milord, somewhere slips, or if he falls down, Milord, that accident may take place at any point of time. And it is, Milord, as if to suggest the 2022 circular says that so many accidents are taking place.
The inquiry is negated altogether. I mean, if an accident occurs, you are blacklisted.
Yes.
Apparently.
Yes, yes. Milord, this is the sum and substance of the writ petition. Milord, I have showed your lordship the order also.
Yes, yes.
Milord, I need not burden your lordship because the order is very clear.
I don't think anything else is required to.
Milord, your lordship here.
I think it will be better in reply.
Yes,
I mean,
it is
what is
better.
their defense?
Yes,
Yes,
yes.
Mr. Paja. The awaited moment comes.
Now, Milord, first submission. Sir, this is a policy.
Mr. Bhattacharya, you will be in charge of supervision that Mr. Paja's microphone works. Even during his argument.
Sir, আমার টান নিন, sir, আমার টান।
You are not speaking, Mr. Paja. That's why it's not working. If you speak, it will work.
কি বলুন?
Sir, আমার টান নিন।
না, না, এটা কার কাজ?
এটা নিন।
কাছে?
হ্যাঁ।
এটা আসছে।
আমি তো করছি।
Just see the irony. A person who doesn't need the microphone, his microphone is working and yours is not. Yes, Mr. Paja, what is your defense?
Yes. Milord, I will make my submission on the basis of the documents they have annexed.
Mr. Paja, first clarify. Yes, definitely you will go in your own way.
Kindly give me 5 minutes time.
Very
I want to clarify, then it will be clear.
Very well. Whatever you please. Yes.
Yes. Now, Milord, this is the policy decision. The object and purpose of issuing this, Milord, to ensure the safety of huge pool contractors. They are supposed to bring the pool contract laborers, public also, and officers also. Not that this policy is entirely against them. I will clarify this from their own annexures. Now, Milord, before that, Milord, I am very sorry to say, one argument was advanced that this policy decision is based on the office orders. The office orders are based on those laws are no longer available in India. Those have been repealed. Why? I am telling you, today the submission is made on the basis of those circulars. But, Milord, this was the
So what was his submission on that? I don't recollect.
Sorry.
I didn't think he made such a submission.
Let me make, Milord, the another way. After this Code of Social Security 2020 has come into force, then, Milord, these laws, the Employees Compensation Act,
Workmen's compensation and other.
are no longer available.
You
Because
say that or he said that? What are you saying?
he said,
Acha.
he said. Now, Milord, suddenly I went and go through this. And I'm sorry to say, this code on social security still has not come into the force in India, excepting one section.
One state.
One
Section.
Section. May I read? May I draw your lordship? Book is there.
The
Code.
Yes. দোকান থেকে কিনে আনছি মনে হয় ওটা থাকবে না ওটা এদের কাছে থাকবে না yes
Lordship, kindly take the trouble. Section 1, subsection 3. I read only one or two sections. I will
whatever yes
trouble your lordship too much. It shall come into force. May I read, my lord? It shall come into force on such date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of this code, and any reference in any such provision to the commencement of this court shall be ensured as a reference to the coming in force of that provision. My submission is that this section, no
So it's
other,
not applicable to West Bengal,
not India.
not India. So let us proceed on that premise. What are the rest of your arguments?
Yes.
Yes. What about security? What about supervision? Whose responsibility?
Milord,
That is the crux of the matter, Mr. Paja.
Milord, I will come.
Who
Slowly.
is,
I
who
will come.
supervises supervision?
Milord, my learned friend has chosen particular portions of some of the circulars,
Hmm.
which actually appears to be against me or in favor of him. But that is not a clear picture.
Right.
Milord, I'm respectfully submitting that I will not trouble your lordship too much.
No,
I
troubling me,
just
Mr.
point
Paja.
out-
Troubling me is not an issue.
No.
You
I'm-
cannot trouble the laborers, the contractors, the contract laborers who are working there. That is the plinth of
Then,
the.
Milord, the first point, again, I'm
They have to have some security.
Milord, who are the laborers here? And contractors. They are enlisted contractor of the
Yes.
company.
No dispute on that.
And when they were enlisted, there were terms and conditions of the
Show me
enlistment.
those.
That is I have annexed in the opposition. Lordship, kindly take the trouble, page 85, annexure R4.
Yes.
Your lordship did not take the trouble, kindly come to 86. These are the terms and conditions of the contractors, enlisted contractors. Your enlistment will generally be guided by the following terms and conditions. Lordship, page 86.
Yes, got it. You can continue.
Milord, 7 first. I am not going to read entirety because no need to waste the court's time.
Mr. Paja, please continue.
Oh, sorry. 7. You shall have to follow all central government, West Bengal government and statutory acts and rules and the regulations. Next, 8. You shall be responsible for compliance of all statutory obligations under the Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, and also be responsible for payment of contribution, both employees and employees under the Employee State Insurance Act and regarding other relevant labor laws as well as circulars orders of our company issued from time to time. Then, Milord, 9. Contractor employees as engaged by the contractor must be registered as per ESI Act, where ESI is applicable, and in case of non-ESI applicability areas, the relevant amount related to ESI should be utilized for purchase of Mediclaim policy from government undertaking insurance.
10 and 11 are probably relevant, Mr. Paja. 10, 11, and maybe 14, I don't know. If you
Yes,
argue.
yes, exactly.
Other clauses are not relevant. Yes. 10, 11, and maybe 14.
Then I'm
No, you can, I mean, 10 and 11 say yes, meet with accident. If they meet with accident, shall be entitled to get compensation, which Mr. Bhattacharya for the timing is not challenging.
Yes.
Compensation as per the act, he is not challenging.
No.
11 says in case of accident, it is observed that contract laborers had no personal protective equipment, PPE. They
Also,
say
this
that
is-
yes, this is very important. yes.
very important 11.
Definitely, they have to have PPE, they have to ensure it. But once they're working, during working, the supervision is yours.
No,
Not yours.
no.
So show me that.
I'm coming. Milord, I will take time, Milord. Some time. Then, Milord.
You continue. If you're ready, Mr. Paja, continue for 2 minutes. You can continue. Why are you stopping repeatedly?
No, you're
Yes, very well. Please continue. I want to hear you. Other matters are waiting. Yes, please continue.
Milord, I won't be able to.
Do you have anything to say? I mean, if you have anything to say, why are you stopping repeatedly? For my convenience? Which are the relevant provisions?
It
Please,
is not your convenience, it is my convenience. I want to
please
go back. I
show me
want to
those.
go out of the court,
Why?
personal reason.
Let us continue.
Yes,
Yes.
let me complete this. Then Miller, 11 your lordship have already.
If there is an inconvenience, real inconvenience, can we continue after the recess?
After lunch, it will be better for me.
Right.
I'm sorry to interrupt your lordship.
No, no, no,
Sorry.
definitely. If you have an inconvenience, why not?
Yes.
And Mr. Das will be here for a few minutes. I will be Justice Das.
Yes.
My lord, before recess, my lord, lordship asked me to make my submission regarding the supervision.
Mr. Pandey, is your microphone active? Please switch it on.
এটা কেন কাজ করছে না দাদা? এইটা কাজ করছে, এইটা কাজ
You have to take it towards you. That's why it's not working.
No,
It has to be
sorry.
before your mouth. It's not that. Yes,
Thank you.
please.
Now, my lord, what appears to me from the annexures I have annexed. Some of the annexures they have annexed, but I have again annexed those, including some others, because some portions are not there, not legible, all these things. Now, my lord, supervision concern, my lord. Lordship, kindly take the trouble first, my lord. It's 39. 37 of my opposition. 37, no, tar aage. This is part of 37 is part of office order number. Part of office number 24, page 27. Lordship, probably my learned friend has already placed it. My lordship, kindly come to page 28.
Not page 37. I'll not come to page 37. You said page 37.
It starts at page 37. That is office order.
It ends at page 37.
Yes, starts at 27.
Yes.
This is, lordship, kindly take the trouble to come page 28
Yes.
at the top 1.2.3.
Right.
All maintenance works and jobs involving HT shutdown shall be undertaken by one of the skilled laborers of the contractor engaged for execution in a shift.
Yes.
So not that they are no responsibility.
Right.
I can place from here, my lord, that my responsibilities are also there. That's why at the outset I said this is the policy decision which touched everybody. Now, my lordship, kindly same thing, 2.4, same page.
Yes.
All maintenance work and jobs involving HT shutdown shall be undertaken by the skilled labor of the contractor engaged for execution. This is shutdown is a very, very important because, my lord, I had the occasion to go there and your lordship did not take the trouble. I went there before starting the repairing work. My lord, the contractors, my lord, phoned the authority that I am going to start the work. You shut down this portion of the. So unless shutdown is there, my lord, accidents.
Definitely.
So, my lord, this is the responsibility of the contractor. They can't say that I don't have any responsibility. Responsibility lies with us. Now, my lordship, kindly come to page 29. My lord, whatever is there, I will place. If it goes against me, let it goes against me.
Yes.
But I will not. I am not shy to. This is not my practice at all. My lordship, kindly come to 3.4.
Right.
One skilled and one unskilled labor shall be engaged by the contractor in each shift of 8 hours for ensuring round-the-clock operation and maintenance job of 33 by 11 kV substation. It shall be ensured that the skilled personnel to be deployed by the contractor shall have adequate expertise and experience for such job and possess the necessary valid license to work in sector. Not that they only ordinary laborers will come. That is why, my lord, this is the policy decision. Now, my lord, the other 4.23456, my lord, this is the mobile phone you need and all these things. I will not take. Only thing, my lord, I can read that once argument was advanced at the time of taking the interim order or moving the writ petition, that mobile van, my lord, they are supposed to supply the mobile van.
Yes, yes.
Vacants. So it is their responsibility. And Miller 7.7. Page 32.
Yes.
As per WBRC regulations, there are specific stipulations from time-bound maintenance, and on default, there are specific penalty clauses. Hence, due to non-performance within the stipulated period of a particular job or restoration of feeder lines, necessary penal action shall be applied and agency shall be liable to pay any such penalty due to such delay, which will be deducted from the concerned contractor agency's monthly contract charges. 7.8. All statutory obligations and terms and conditions incorporated in this order are to be strictly complied with by the agency. In case any deviation, non-compliance is notified, the controlling officer will take necessary administrative measures immediately. For repeated failures, after 3 such occasions, the agency may be terminated without any further refund. So, my lord, it is not that they are not aware. These were there, and my lord, times without number, your lordship put a question to my understand that are these things are challenging your challenging.
They are not challenging this.
Rather, they are banking on these.
Yes.
So, my lord, the contractors were aware of all these things. কত প্লেস করলাম? Now, your lordship kindly come to now, my lordship, take the trouble to come page 37 of the same.
Yes.
Capital letter E.
Yes.
4.
Right.
Supervisor of the contractor company should maintain another job register for day-to-day preventive maintenance work done by the concerned HT gang. So, my lord, all these things were there. They are aware of all these things. In spite of that, they have entered into the contract with us because, my lord, they are listed contractor that have annexed the terms and conditions of the contract I have placed already below. That is page 86. That just lordship need not take the trouble to read. May I read only one line? I will read.
Yes,
Page 86. What I would say that you shall be responsible for compliance of all statutory obligations under the Minimum Wages Act, Payment of Wages Act, and all these things. My learned friend submitted that after coming into force of the code, all these laws are not available in India. That is not. I can place the document of the central government that this code still has not come to force, excepting one. May I place your lordship?
Regarding what, Mr. Panja?
After the code has come into operation, my
Yes.
friend submitted that this
Code is not important. They're not denying their liability to pay this.
No, I'm not saying that. How they have advanced their argument. That is what I'm saying. Because they have obtained the interim order.
Anyway, let us continue. That is not a German factor in obtaining the interim order.
No doubt about it.
That was never discussed in the interim order also. This code coming into place of something else, no. That is not relevant at all.
That
Yes.
submission was made on second time.
Several submissions are made. This is not a German submission. So let us continue on.
Lordship.
So which clauses of page 86 you are relying on? You said page 86.
86,
Which particular clauses? Give me the clause numbers.
terms and conditions.
Yes, you are placing page 86.
Just I've already placed my lord, actually, my.
7, 10, 11,
8, 9, 10 and max. Well,
8,
11.
9, 10 and 11.
11.
All right. Very. Yes.
Now, my lord, there is a another office order, page 87 next.
Yes.
Did not give any trouble because there is a renewal also.
Gotcha.
And while they will renew, same terms and conditions will follow.
Yes.
Now, Lordship, kindly, I have placed already page 88, probably I have not placed. Only one, clause 9. If the contractor laborers meet with an accident while working in the system of the company, resulting in death or loss of earning capacity of the labor, his legal heirs, concerned labor, in case of loss of earning capacity, shall be entitled to get compensation as per prevailing Employees Compensation Act and all these things. In case of accident, 10, in case of accident while working on the system of WBSC-DSL, it is observed that the contractor laborers had the personal protective equipments and other safety standards were not observed, and due to which accident occurred, actions will be taken against the concerned contractor, including the prosecution under the Indian Tail. So the day they were enlisted, they were aware of all these things. So my endeavor here is, my lord, they are saying as if they are not aware of all these things. They are very much aware. Only then they were accepted the job. It's a serious matter because if somebody is electrocuted because non-performing of these terms and conditions, there is taking shutdown, supervisor is not there, then there is no other alternative but to death. And Millard, we also knows the newspaper report all this time that local office is ransacked. Because death is not a matter of joke, my lord, there. Obviously, my lord, the local people will ransack. So, my lord, my endeavor is this, that they are aware of all these things. Now, my lord, page 67 probably I have not placed. Page 67, my lord, order number P by 71. That is the whatever I am placing the documents for my opposition, because these are visible. Subject.
Yes.
This is of 22. Administrative action against the contractor in case of any fatal work accident. 67.
67.
No.
This is also one of the impugned things.
Lordship?
This they have also challenged this.
No, sorry. This is 69 probably. Yes, sorry. I'm sorry. Very sorry.
69.
69. Sorry. My land friend, I'm sorry. Administrative action against contractor in case of any fatal work accident.
This is the impugned one. This has been impugned in the present writ petition.
Yes. So, my lord,
this has been challenged in the present writ petition on the ground that it is dehorts the previous ones.
My lord, I have already placed it from the office order that they were aware of this. They were aware.
Yes. Aware of what?
That this accident, if there is accident, what steps would be taken by me? Because it is, again, I am putting a question to myself. This is a fatal accident. The huge things, And my lord, immediately after my lord, that portion, I've asked my learned friend. That my lord, I have Lordship, kindly, page 72. This is part of the circular dated 26 March 2008. Lordship need not read entirety. Just above Roman 4 towards the bottom.
Yes.
To ensure strict compliance of the statutory benefits, the controlling officer are advised to obtain statement in the prescribed format enclosed and verify the same before releasing the next subsequent bill of the contractor. Now, why I am placing again and again, troubling your lordship, that all these things are known to them so long they were working on this. Committee could the committee could yes.
Anything else, Mr. Madha? Yes.
Just
Yes, please. What is that?
your lordship, kindly come to page 75 once. The duty cast upon DCL officers also. Because this is the policy, this is not confined to only the contractor. It touched me also. Responsibility fixed on me also. Middle paragraph.
75 or 78?
75.
Yes.
Part 2.
Yes.
Compliance for compulsory use of safety induction form. This, may I read, my lord? Compliance for compulsory use of safety induction form before commencement of any work of the contractor has to be ensured by the concerned site officer, and it has to be preserved subsequently under the control of divisional manager. So that responsibility cast on me also. Why? Because safety induction form has to be. What is safety induction form? Lordship, kindly turn the next page. Before entering the work job, they will have to sign on this. May I read, my lord? I shall follow all safety rules and the regulations of distribution company and shall be responsible for observing safety rules and regulations by the workmen engaged by me during execution of work. I do hereby declare that work will be carried out by such and such numbers of workmen engaged by me as per norms and requirement of the job by using safety gloves, helmet, safety belt, discharge rod, including tools and tackles of required numbers of prescribed standard. All other necessary safety aids would be provided if necessary, and their application will be explained. Then, my lord, instructions, last portion. Instruction has been given to comply with shutdown norms, safety rules, and regulations. PPEs are supplied, provided by the contractor agency. Contractor agency has been advised that PPEs must be used by all the workmen. So my lord, they cannot say that I have no responsibility. I am only supplying the laborers. That is not. And my lord, lordship kindly come to my land friend has placed that if there is a fault with me, then there is a blacklisting. My lord, I have annexed that also. Page 78, very next page. Lordship kindly read only one line from the top. Permanent Enquiry Committee, wing was, are hereby constituted comprising of the such and such officers to inquire into the cause of fatal and non-fatal accidents. Not that as soon as accident happens, I am saying that you are blacklisting. Next page, my lord. The bold type, broad terms and reference of the committees. Committee are not, my lord, also, my lord, the under the DCL, my lord, that they are not free, everything. So, my lord, as soon as accident happens, they are blacklisting and then gone, not that at all. Committee is there.
Mr. Paji, it's not about committee not being there. If you please come to page 56 of the writ petition, the impugned office order dated 28th of July 2022 by the HR.
56. Plus, I'll give you one.
Yes, take your time. Please come to that.
No, I want-
28th July 2022, that is the impugned office order.
Yes, office order number.
Now, if you please come to the second last paragraph of that, it says, in view of the above, it is hereby directed to all controlling officers not to allot any new job order to the agency or contractor as per approved rate contract if any of his/her labor meets with the fatal work accident until the findings of the permanent inquiry committee.
This is important. Might not get put.
So you employ a permanent inquiry committee which is continuing the inquiry for whatever time. Until that comes out, you are blacklisting these people. You are saying that no further work order will be issued to them. How can you pre-decide the committee's decision?
No.
You are banning them from anything else, participating in any contract till the permanent committee inquiry report comes out. It should be the other way around. If they are incriminated or indicted by the permanent inquiry committee report, definitely you can blacklist them. Go and blacklist them. You have a right. But unless the committee report comes,
Absolutely.
how can the presumption be that they are guilty and they're not only terminated, they're blacklisted forever?
No,
for
no, my
the-
friend has said this is not the blacklisting. For the time being, they are not being allowed. And Milo, that portion I am not in a position.
What is the meaning of blacklisting in commercial terms, Mr. Paja? Tell me.
That is there. That's why.
Tell me what is blacklisting. You don't put them on a black colored list.
No.
You don't allot them new jobs. That is blacklisting or holiday listing or vacation listing or whatever. Here you say not to allot any new job order to the agency contractor as per approved rate contract. And that is in bold letters.
Yes, that is a new job. Milord, I was going to make this a new job. The job is continuing. Milord, they will not be debarred.
That is more ridiculous because no new job will be given to them. Also, they will be carrying out the job in which they committed the breach. You have to understand that also, Mr. Because otherwise termination is a lesser penalty.
Yes.
I terminate your present contract. And the other one is I blacklist you from participating in any new contract. Now, here you are saying that no new contract will be allocated to them. Fair enough. If there is a preliminary report even by the committee, I can understand. But I mean, if it's your fault, support your supervisor's fault, why should they be blacklisted? You should fix a time limit for the permanent inquiry committee to give its report.
That is there. I'm not.
That is also there in page 37. That
But Milord, I'm not.
page 78, 79, yes. Where is the time limit there?
Milord, that is another circular.
Acha, where is that?
That is why, Milord, I'm not.
No, not another circular. You place that. You placed that. That is at page 80 of that.
Yes.
Page 80 says within 30 days. 30 days.
Yes,
Page 80 of your opposition.
yes.
I've seen that. But this circular is of July 2022. We are in August 2023.
Yes.
No report has yet come. We are a little over 30 days.
My lord, this is.
We are going to reach 30 months probably before this report
My lord,
comes.
matter is sub judice.
Sub judice means?
Sub judice
That's
means-
why the committee is not giving a report. There was no restraint order, Mr.
No, I'm sorry, I'm not saying
Sub
that
judice where?
my land friend has not come with something, some incidents where
No, what is sub judice?
fatal accidents. The entire.
Mr. Paja, my question is very clear. Let us not
I've
beat about the
understood.
bush.
I have understood.
I'm not a big fan of beating about the bush.
No,
I'm telling you.
I have understood.
Mr. Paja, my clear question is the committee, as per your report, this email says it has to furnish its report within 30 days. The impugned circular was issued on July 28th, 2022. We are almost in the end of August 2023. More than 1 year has passed. The report has not yet come. What have you done in that regard?
My lord, I'm saying, my lord, the report of which accident? Which was the accident?
Acha, you are saying no particular accident took place.
I don't think, I probably, I may miss, but.
Acha,
I do
very
not
well,
find
very
any such. But my endeavor is this holiday listing or the blacklisting not forever.
No, till the permanent inquiry report comes.
Yes, and permanent report will come within 30 days.
Oh, you say that 30 days is the outer limit.
Yes. Because, my lord, indirectly, my lord, they are working.
All right.
And they are enlisted contractor.
Mhm.
My endeavor is, my lord, again I am saying
Hmm.
that to ensure the safety of huge pool contractors, including the.
So, Mr. Paja, is it your submission that the outer limit then will be 30 days
Yes,
of this, whatever you call it,
yes,
holiday listing or
yes,
not to allot any new job order?
yes.
So that outer limit is 30 days.
It is there. Page কত বলো?
Suppose the report does not come in 30 days, what is the mechanism in place?
May I read that should be furnished? Should be furnished. They're bound by that. If the
Court orders are not complied with, Mr. Paja, that's why contempt jurisdiction is there. And your email should be furnished within 30 days. It will be done within 30 days. Their blacklisting will continue forever then, whenever it is done.
this is
So
not-
we have to take the margins. I mean, that cannot be, then it should have been, Mr. Paja, then I'll read that into it if you say so. That which will be until the findings of the permanent inquiry committee inquiry comes out, or until 30 days, whichever is earlier. If you say that will have a different connotation altogether, then it cannot be permanent. You are right on all the other scores. I mean, then I'll read that into this.
My lord, I am told.
That's
I
a
am
very high argument,
I-
because then it has to be limited to 30 days.
30 days.
Whichever is earlier, 30 days odd inquiry report.
Now, my lord, that paper is not with me, but I am told. I am told, your lordship kindly take it.
Told
That
by
if-
WBSCTCL.
Yes.
I've been told many things by WBSCTCL, not complied with.
Your lord.
Your client has told me many things in court, not complied.
Yes, I am not ignoring. My lord, if the fact is there, I cannot ignore.
What have you been told? Let me hear that for curiosity's sake.
I am told that even one person has been, my lord, blacklisted. But even then, the work he was doing, he was continued to go on, but not any fresh.
All right.
Till 1 month time elapsed. Not that permanently. My lord, lordship kindly, one thing, my lord, I'm
No, I
trying
can put that into my order while considering this. That would suffice.
Yes. Now, my lord, my endeavor is this, my lord,
Mhm.
that it's a accident in the life.
Mr. Paja, there is no doubt. Otherwise, it's
accident.
all right. The inquiry report, if the inquiry report says that a person is guilty,
Yes.
prima facie that you can restrict that person from working.
Yes.
There is no doubt on that. Cannot be any doubt in law. You have that right. That much right you should have. But the question is whether that can be for an indefinite period. That is the one of the premises.
Your lordship kindly make that observation.
This is one aspect of the matter.
Yes, lordship kindly make that observation.
And the other aspect which you said is that the present work in which they are, the present contract in which they are working, that will not be stopped.
No, because they are performing other jobs also.
Acha, what happens if they are held to have been guilty of the offense after the inquiry report comes?
Yes.
Then what happens regarding their continuing job?
I am very frank with the court, Millard. I don't have any instruction on this. I can speak to my
That's a
client.
doubtful area. That's on a different footing, though.
No,
Yes.
I can speak to my client also.
No, that's different. I mean, yes, definitely.
Actually, Millard, what troubled me,
Hmm.
that Millard, again, I'm saying, I'm sorry to repeat. Usually I don't report. That Millard, this is a fatal accident on the line. My officers also, Millard, they died. So, Millard, I want to minimize that. Environment free. Accident, environment free. Accident.
Do whatever you like to do that. Definitely, that's most welcome. But Mr. Pandey, you cannot do something which is beyond the principles of natural justice. So you say it is 30 days. 30 days, and present work is not affected until a report comes. The worst thing will be the report comes, then you take penal steps that you can take.
Yes.
Hmm. But then the presumption is that they are guilty.
I do not know.
Even then, even if it is 30 days, even if for one day, Mr. Paja, before the report comes, then the presumption is that they are guilty.
Millard, if I say in this way, if your lordship permit me,
Yes.
it is also go to in other way round.
Like?
Suppose Millard, other organization, if there anything done, immediately blacklisting goes, observing the principle of natural justice. Here we have one step more. That inquiry committee, if they found they are guilty or something happened.
No organization can directly blacklist.
No.
If they directly blacklist, that is one of the first grounds it will be rejected.
I said they after observing the principle of natural justice.
How?
Because Millard,
if it is immediate blacklisting, where is natural justice?
No,
I mean,
not immediate
satisfied.
blacklisting. Here also I am not immediately blacklisting. I am saying that is why, Millard, I put the time 1 month you complete this.
All right. Very
You cannot continue the inquiry days in and days
out
together.
yes.
Because they are enlisted contractor. I need their job. I need their job.
One other aspect of it, Mr. Paja, initially when it was argued, it was sought to be pointed out because this argument was made. Now, this page 56, this you said not to allot any new job order to the agency or contractor. This is being interpreted by you as a new work order, sort of. Now, but the petitioner was of the opinion, at least initially when it was argued, that this new job order, the job orders are issued every day. So this non-allotment of a new job order to the agency means from the next day, the current work is also affected. Can I record your submission that it is not so? I mean, the new allotment of new job order to the agency, that is being stopped by you for 30 days. Now, new job order, does it mean a new work altogether?
What I am told. Then I will have to talk with
Let us see one of your job orders.
No, then I will have to talk with my client.
Before having a talk with your client, more authentic is your job order itself.
Yes.
Let us see the job order. Any job order annexed here? Mr. Bhattacharya, please check up and tell me.
Supplementary.
Supplementary, right. You are showing that. Let us see the job order. What is the nature of the job? Supplementary activity, yes.
Yes.
Those draft copies?
Yes. Page 29.
Page 29.
Yes.
আমার কাছে তো নেই রে এইটা দেখাচ্ছিস
এটা আপনার অপোজিশন
সরি এইটা তো পড়া যাচ্ছে না ঠিক
But page 23, it starts at page 23. It's at Bhattacharya, page
Fine.
23 of a supplementary, if it please come to that. 29 is midway between that.
Yes.
23 says, Dear Sir, Madam, with reference to your consent letter dated such and such, we are pleased to place the formal order with you from 1st of April 2022 to 30th of November
For the
2022.
jobs in connection with repair and maintenance of such and such 11 kV and 39 kV feeder lines on the monthly contractual rate as per practical details below. Particulars.
If it is
details-
monthly contractual rate, Mr. Bhattacharya, it presupposes it cannot be daily. Then it would be a daily rate. How can you fix a monthly rate for a daily work? Cannot.
It is the subject matter of their interpretation, but new job orders,
Nothing
according
appears
to me, Milord, it is an blanket, stay on the work that I am discharging. Kindly looks into the order once again. The 2022 order.
With reference to your consent letter. That is also there. Page 56.
Compositional.
Consent.
In view of the above, it is hereby that all not to allot any new job order as per approved rate contract presupposes, the rate contract that was approved, the one, that your lordship just
monthly, which is a monthly.
monthly, new job order will not be allotted.
New job means
Not the next following month, maybe. It presupposes the following month. In the event, it's not in the.
Here, Mr. Paja has argued something that there is a committee in place, inquiry committee, till now, still now.
Well, that was there in 2008 also.
That is still there, page 78, and that has to submit a report within 30 days. So if it is within 30 days, he says that this is till the committee submits a report, then this is restricted to 30 days, not for a, not
This
a
is,
blacklist.
with deepest of respect to him, that does not flow from the order.
No, order says within before the committee submits its report.
Yes.
So he says this committee has to submit the report within 30 days.
Until the findings of the permanent inquiry committee comes out, it means, that I will not be given any new work order until the permanent committee gives the report. Kindly reads once again, subject to correction, page 56. In view, I am looking at the writ petition. In view, it is hereby directed that all controlling or not to allot any new job order to the agency as per approved rate contract means the rate contract at which I was engaged.
Mr. Paja, another thing, if you say as per your interpretation, if the job orders are not daily, it's a contradiction in terms for you then. Because you are saying in the same breath that the job order is not daily, but at least monthly. And you say for the next 30 days before the report is filed, he will not be given a new job order. If it is a monthly job order, where is the question of giving a new job order within 30 days?
Job order means, actually, before that, I'm putting a question. Suppose 30 days over.
First answer my question, then answer your question. I have also put a question. You have also put a question to yourself. You can answer that your question later. Answer my question first.
Yes.
My question is very simple. If you say it is at least a monthly job, not a daily job. Suppose it's a monthly job, but in your impugned circular, you say for 30 days, no new job order will be issued. How do you reconcile the two? Where is the question of issuing a new job order within 30 days?
Yes, I'm saying, is there any complaint before this court that 30 days over have not been?
No question of complaint here, Mr.
If
Panja, we are on
days over, then he will get
what
the
do you say?
work.
That is not an answer to either of our questions, not to your question, not to my question.
Means, this is, I'm not clear on this. Because whatever is there, I have annexed.
No, you have to be clear on your argument.
Yes,
your argument is that within 30 days, in the same breath, you are arguing that the tenure, maximum tenure of this blacklisting or whatever is still 30 days. And then you say the contract is, the tenure of the contract is not daily basis. It has to be at least a month, suppose. Suppose the contract is worth at least a month, then where is the question of not allotting him a new job order within that month? I mean, you cannot go together unless it is a daily job. You have to choose one of the arguments. Either it's a 30-day period or the job order is regular, daily.
Miller, my argument, whatever is there, Miller, on the basis of this, within 30
Has
days.
to be on the basis of this.
Yes.
You cannot invent something. Somewhere.
That's why, Miller.
What is your argument on this?
I cannot. Miller, my argument would be, Miller, what I have understood, that suppose there is an accident. He will not be allowed to work again till 30 days.
So daily basis also he cannot work.
Till 30 days means no other work.
No other work means a new contract won't be awarded to him.
No. That is the same, because Miller, the accident occurs in a particular job.
What do you say is the tenure of a job, length of a job? 24 hours or for a longer period?
No. It depends.
Depends on what? Your submission.
It depends 24 hours because somebody.
Depends on what, Mr. Panja?
Lordship?
Depends on what?
Suppose, Miller, 1% there is a complaint of blackout.
So there may be 24-hour jobs also.
Might be.
If there are 24-hour jobs,
Yes.
then your blacklisting is from the next day. He cannot work from the next day. So why should he be restrained for 30 days without a permanent inquiry committee report coming?
Miller, that permanent, what I've come to know, that 30 days means on this particular job.
If the job is daily, where is the question of this particular job? Once you are saying that particular job he is entitled to carry on.
Suppose
another time you are saying no, it's the other way around.
Suppose a particular job will continue for 10 days or 20 days.
Mr. Panja, you told me that this restraint is for new jobs. As per the circular, that is so. No new job will be awarded to him. And he will be able to carry out the existing job. Then for the next 30 days also, he can carry on the existing job.
Miller, before allotting the new, there are some formalities are to be required. Not that a new contract, definitely new contract. New job means on the basis of new contract. He is apt to enter into the new contract.
We cannot play on words, job, contract, whatever. If you choose the word contract, I agree to that. Let it not be a job, let it be a contract. You say a new contract won't be awarded to him.
Miller, job comes after he entered into the contract. That I have placed already.
Your circular, impugned circular does not say contract. It says job order.
That is, yes.
So it is contrary to your argument. You said no new contract would be given. But your circular says not to allot any new job order to the agency, which is on a daily basis then. Then you are wrong on that. It does not say new contract will be awarded. Then it would be a different interpretation. But you are all along the basis of your argument is no new contract will be given to them, but they will be entitled to carry on the existing job. It does not say so. It says not to allot any new job order till the inquiry report comes.
Probably
today an accident takes place, he won't be able to work from the next day.
Yes.
So then where is the
And
national
he
justice
have
compliance?
to wait till inquiry committee 30 days fine.
Why should he wait? Why shouldn't he be permitted to work till the inquiry report comes? And then if the inquiry report is against him, then blacklist him. That should be the law. Even under criminal jurisprudence in India, one cannot be held guilty before he is decided to be guilty. So how can you blacklist him, restrain him from working from the next day onwards, just because an accident has happened? Suppose your employee is responsible for that. Maybe situations. The inquiry report ultimately reveals your employee is responsible for that. If that be so, why should this person be blacklisted for the next 30 days till the report comes? How can you compensate him for the 30 days?
I place whenever a job is allotted to a person or contract, because job is not allotted without entering into the contract.
That is neither here nor there, Mr.
Yes.
Panja.
No,
I am only on this circular. The circular says not to allot any new job order. What is the meaning of a contract? We are not bothered about that. You won't be able to allot any new job order to the agency till the report comes. That is the language here.
Job order, I'm saying probably if it's correct,
Because his employees will also be sitting for those 30 days. We have to keep that in mind. These are mostly daily laborers. Contractual laborers are in any event not paid the usual wages by the contractors, by Mr. Bhattacharya's client also maybe. But let us not be on that. Let us wait for a suitable litigation for that. Now, whatever little they're getting, those employees will be sitting for the next 30 days without any fault of theirs. Because one of their compatriots have died in an accident, the other 30 employees, the other 100 employees will be sitting over. Why? Why should the contractor be blocked from the next day? No new job order would be issued means. You have said no new job order would be issued till the report comes. Why? What is their fault till the report comes? Who decides that they are in fault? The report may say so. You are right on that. Let the report come, let them be held guilty, do whatever, take whatever steps, they'll challenge that before an appropriate forum. But before that, for the 30 days, why should they be sitting? And their employees will be idle also. That is a larger consideration, Mr. Pandya. Anyway, so this is all. Yes. Reply.
One page. Please see page 29 of the supplementary affidavit once.
29.
Yes. In the 2022 document,
There one more submission may I make?
Achha, let Mr. Pandya complete.
Sorry.
Yes, Mr. Pandya, what else?
Lordship, probably one answer would be there. My junior has helped me.
Yes, tell me.
56 of writ petition.
56 of writ petition, yes.
28 July.
Yes, I'm there.
The last but one paragraph.
That is what I placed before you.
Lordship.
That is what I read out to you.
Yes, that is that until findings of the permanent inquiry, committee
The
development.
junior pointed it out this to you after so much time.
Yes.
After this lengthy argument, your junior is pointing out to this until. I'm really flattered. I mean,
I said there's such temporary abandonment.
yes,
I'm on that.
you are on.
Temporary
Such temporary debarment shall continue until inquiry proceedings.
and subsequent action are complied with.
So it is on a larger footing. So Mr. Bhattacharya should have pointed this out. So it is not only till the report comes.
I'm saying that I'm on this because of temporary, what temporary? Not that permanent. Temporary. I'm not
Temporary.
ousting him.
The world is temporary, Mr. Pandya. Why argue so much? Temporary is absolutely relative. You don't require an Einstein for that. Temporary till the inquiry report comes and until inquiry proceedings and subsequent actions are complied with. So it's then permanent. What is permanent, Mr. Pandya? Tell me something which is permanent in the world.
Death.
That is also not permanent.
Death.
Not permanent. How do you say? It's an event in time. This was what you were wanting to point out, Mr. Pandya. Thank you for pointing out.
I have also no answer regarding the temporary and permanent. Today,
You are the one who has to have an answer. Otherwise, you lose the case.
Yeah.
I don't require an answer. I'll just adjudicate on whatever answer you give. But you are the one who has to defend your client, Mr. Pandya, not me.
State কোথাও নেই
State বলতে senior নেই।
সিনিয়র নেই সে কি
Yes, Mr. Pandya, you want to add anything else? We cannot wait for Mr. Chaudhary to find out some other point. If he's ready, please argue that.
I'm not
So let me hear the other side in reply. Take your seat. Yes.
only thing Milord, if really this question Milord or serious, well, I want to speak to my client.
You have a talk with your client, but that will be regarding the preparation for the appeal
No
at
question
that
like-
point of time, not
But-
before that.
no Milord, I want to meet that point. It's very important point your lordship
Meet it, Mr. Pandya.
that
But this matter is over. I cannot give further time. This is continuing for months probably.
Yes, yes.
Milord,
No.
month probably not, but more than that. But Milord, I have not asked for
It is my fault. It is continuing for more than that. I am taking the responsibility.
I am not blaming him. Why
We'll
should
do a toss on that, Mr. Pandya. Let us not argue on whose fault.
Only
That will take half an hour more.
only 29, just paragraph 35 kindly sees. paid.
You misled me on one point. You said you are not challenging 2013. But in your writ petition, pair C or D is challenged to 2013.
Maybe it escaped my eyes. I'm sorry.
So are you insisting upon that challenge or not? Tell me, I choose either of the two.
Yes. No, I was wrong. I was.
So you're challenging,
Yes.
still challenging.
Whatever is there is there. I have not, my lord.
Page 29 of the supplementary
Yes,
was.
only one paragraph, paragraph 35. Kindly reads, my lord,
Yes.
of the supplementary act.
Wait, give me half a minute.
Just I'm kindly not strain your lordship's eyes. My lord, this is of 2022.
I'll have to strain my eyes.
কি করবো বলতো, এটা একটা কপি দিলি না তুই?
No, why not strain my eyes? I mean, I'm here to strain my eyes. I love straining my eyes.
That's your lordship's choice.
Yes,
Your lordship
29 years.
chose to strain your lordship.
29 is nothing. We are insisting on 20.
This is a part of the conditions. What I am on is even in 2022, they say that, my lord, the contract labor in the event of an accident will
Which
be
clause?
35. If the contract labor meets an accident while working on the system of the company, resulting in death or loss of earning capacity of the labor, his legal heirs such and such shall be entitled to compensation as per Workmen's Compensation Act, and such compensation shall be paid by the SEBCL through the Commissioner Workmen's Compensation following the guidelines as per circular dated 26 March 2008 of the Director HRA WBSC.
But they have provisions to recover that from you also.
Yes. But what I'm on is, they don't even refer to or even vaguely refer to any subsequent circular of theirs. So, 26 March 2008, according to me, forms the basis of this entire, scheme of things. And, even in the 2022, draft condition, 26 March is referred to, and it says, that if one has to be paid the compensation, it has to be guided and routed through the 26 March circular. And
Mr.
nothing
Bhattacharya,
on
we
supervision.
cannot injunct them from issuing new guidelines.
No, 100% no.
Cannot
But,
do that.
it has to be in consonance with,
Only thing which
Article
has
14.
we have to see only that. Article 14, 19 also in your case.
Yes.
19 also.
রেকর্ডে নেই, এটা কি দেখা?
Very
এখন
good.
আর নতুন কিছু আবার গন্ডগোল।
তন্ময় ছোট ওই উঠতে হবে না heard learned counsel for the parties judgment is approved.
Great.
Thank you. Interim visibly relieved. Mr. Paja.
The interim order is to continue.
It was till disposal. Or
No, 31st.
interim order granted earlier shall continue till the disposal of the writ petition. পাঠিয়ে দেবে কেন? না সোশ্যাল সিকিউরিটি অ্যাক্ট লাগবে না দেখি।
তিনটে বই ছিল এখানে তিনটে বই
These are court's books. Your books have gone back. Don't cast aspersions without being sure. Yes.
Lordship, sincere apologies, Lordship. I was on my legs.
Apology accepted, but for what?
It's for the state. She has to
I
make
was
some
very
submission.
State, Lordship. As on date.
And it's her birthday. Kindly do not scold.
Happy birthday and thank you. Next matter. So নামটা রেকর্ড কর বার্থডেতে নামটা।
Grateful.
Mr. Chakraborty is waiting.
Item 9.
Yes.
He has called me 3 times to ascertain whether this is going to continue.
Anything else, Mr. Chakraborty? Apart from what you have already argued?
Lord, the Food Corporation of India has filed an affidavit disclosing what is the amount.
Awaiting to receive a copy of the affidavit. My lord, it is me who has to reconcile with my statement, and I am awaiting my lord.
But
petition has got nothing to do with the affidavit. We have to reconcile whether the bills have been payments have been made. I have not yet received.
may I show your lordship's lord, I have been served with a copy today morning. I have served with a copy of the.
Year for?
For FCI, Food Corporation of India.
Give a copy to them.
It was my mistake, I caused service
No,
of
I-
inquiries and I was somehow my direct.
You are appearing for?
Central Warehouse Corporation, my lord. That-
Yes, they have to have a copy, yes.
Yes,
they have
my
to have a
lord. I
copy.
have to have a copy.
But my statement that the amount is credited, that is accepted by FCI on that particular ground. On the particular head, the entire amount is credited. And in 2022, they have not paid me. That is apparent from the report. That is an admitted position.
Who has to disburse to you?
Not the central warehousing. Lord, both are
Say
the.
was to allot the
Lord,
money.
I tell you, Lordship, Lord, this is not in the distribution system. The FCI keeps their Lord rice and all this blood in
Yes,
the
yes.
godown maintained by Central Warehousing Corporation.
True, true.
As per the statement, blood Central Warehousing Corporation, they blood issue tenders and engage us as the handling and blood management contractor. Now, blood we raise a bill, they forward it to FCI along with 8% service charge. They charge blood additionally to the FCI. Now, the bill that I have raised, the security deposit, my father was the contractor, he died. Blood.
FCI is not a party here, is it?
FCI was added as a party blood by Justice blood Mosumi Bhattacharya's order blood. His hard
Yes,
leadership blood
right, right.
directed us to add FCI. FCI has appeared. Now, blood on the last occasion, my lord was blood of the view that blood their defense against non-payment, your lordship blood has already decided that it is untenable. Only thing my learned friend said that they want to verify on what rate exactly FCI has made the payment. Now, my lord, from the affidavit, it is absolutely clear that not on the particular head on which I raised the bill, they have made the payment. If he wants to consider and come back, I cannot stand in the way. But it is now apparent that they should release the.
May
They should.
I submit one thing? What actually happens at ground level is that they submit the bills to us. We forward the bills to the food corporation because they are directly serving the food corporation. We are the mere custodians. Now, FCI is the depositor who has to pay the petitioner through me. Now, my lord, the amounts which have been disclosed here, I do not know. We have a running business with the food corporation. Now, my lord, a huge amount was withheld by food corporation on the ground that there was theft, there was loss of gunny bags. And from time to time, my lord, way back since 2021, FCI has released amounts in part. Now, we have to ascertain whether the bills which are provided by the writ petitioner and the bills which are being released by FCI are identical or not. We need to reconcile this.
Give a copy to him. You are using a reply? No, you are not.
No.
You're
Today morning I
you're
got
relying
it.
on this.
Yes, yes.
An affidavit in opposition filed by the Food Corporation of India.
Report on affidavit.
Very well. A report on affidavit filed by the Food Corporation of India today be kept on record. Full stop. Although a copy thereof has been served on learned counsel for the petitioner during the course of today, comma, no copy has been given to the warehousing corporation.
234.
Being respondent numbers 2 to 4. Full stop. Learned counsel for the warehousing corporation submits that the said corporation is required to go through the averments and annexures of the opposition of the report of the FCI before taking further steps and making submissions. Full stop. Accordingly, a copy of the same may be handed over to the learned advocate for the warehousing corporation during the course of the day. Full stop. The matter shall be taken up for hearing. How soon can you come back with
2 weeks?
Not 2 weeks.
Well, 10 days at least.
3 days.
10 days for considering
One
this.
week.
No, you are
One
sufficiently
week,
mobile.
one
I mean,
week, one week.
literally mobile and figuratively mobile
Yes.
both.
My lord, 1 week. 1 week. I pray.
Mr. Chaudhary, 1 week for
My
this.
lord, I
In
would
these
not.
days of
My lord, 1 week. 7 days.
e-progress.
7 days. My lord. And my lord, one indulgence, I may use an
Very
exception.
On August 30, 2023, when it will be listed fairly at the top of the list, full stop. In the event the warehousing corporation intends to use an exception to the report filed by the FCI, comma, the same will also be filed on the next returnable date with an advance copy to the learned advocates for the petitioner as well as the FCI.
Only one indulgence. Keep it open for us also. Only one point we may also take an exception, but not on the main point. If the party is not.
So the petitioner will also be at liberty to file any exception to the report filed today, comma, if they so intend, in similar terms as the warehousing corporation,
Grateful.
with advance copies on
My lord, on 30th.
Obligation.
Yes. What is this? Compilation? What? Mas, I guess you will.
Original side matters, any mentioning?
Before my lord takes the original side matters, may I just mention one thing, your lordship? Item number 14 and 15 are very small matter, your lordship. May it just retain the position in tomorrow's list, your lordship.
Appellate side.
Lordship, yes. Only retain its position because it won't take time.
No order
Only,
need to be passed on that.
only seeking direction upon district magistrate, your lordship.
No,
May it
no,
retain its
I'll not
position.
pass any order on that.
No.
No. এটা সেট করে নিন বাই চান্স এটা খুব নড়বড়ে কিন্তু না সিরিয়াসলি মাঝপথে পড়ে গেলে তো অ্যাক্সিডেন্ট হয়ে Yes.
Listed matter, item number 1,
Yes,
Sri Oshini Kumar Damani versus
My
State of
application. Millard, this relates to Millard, a cooperative society by the name of Marshall House Owners Association, Millard, which are basically a managing society, Millard.
Right.
Millard, so far as the first point, the society has to be sued in the name of either the secretary or its president, Millard. Those are there, Millard. Marshall House, respondent number 3, Millard, represented by Secretary Mr. G.D. Malhotra and Millard Mr. Ashok Kumar Mittal, who is the president, Millard. And Millard Utpal Jalan is Millard the treasurer, Millard, who has Millard resigned just before Millard the signing of the balance.
No, they took a section 23 point also. Section 23.
This is Millard now the section 23 point. Now let us Millard take Millard the section 23 point first.
Societies registration একটা আছে আগের দিন was there.
Millard, I have a Millard, I am a member allottee.
Yes.
Millard,
The point taken was Mr. Ghosh that it is
I have a
contained
member allottee, it's my complaint or Millard, my information. My information, Millard, to the state authorities as well as copy Millard to the registrar of the societies. That Millard, there is defalcation of funds. There are huge bad debts which are not recovered. FDs have been delivered.
Mr. Bandyopadhyay was to place judgments on that point.
Yes, I
Let him
also
place
have
the
judgment.
judgments. This is the maintainability point. If he places the judgment, I'll give you leave to content. Yes, Mr. Bandyopadhyay. Side judgments. This is only on the maintainability point now.
I also have the judgments.
Not on maintainability because they asked for a simple player of consideration of their representations, which comes within the purview of section 23. And that is the prayer made. And they asked for this.
That is also on maintainability because
Yes,
the
now
repetition
I
is not
say that,
maintainable.
that prayer cannot be granted.
Obviously, definitely.
Now, if you also kindly take smaller.
The matter was adjourned for your citing of judgment.
Yes, I'll certainly.
In fact, Millard,
Section 23.
No, I'm not.
Millard, in fact, Millard, the coordinate benches, there is maintainability not decided.
Not in that language, whatever
That
language.
Millard, but Millard, coordinate benches in this type of matters have asked the authority to consider, Millard. And now we are coming back and there are Millard 3 or 4.
That
I
was
don't
what
say
I was
judgments.
also intending, but it has to be decided once
Very,
and for all.
very well.
Since Mr. Bandyopadhyay wants to side judge, sir.
The locus can be decided
The
by
fault
the
is
authority
entirely Mr.
itself.
Bandyopadhyay.
Very well.
If you also kindly take the preamble of the act. The purpose of the act.
Right.
An act to provide for the registrations of literary, cultural and scientific, political, charitable, religious and certain other kinds of societies and for matters connected there.
This book is of which year? Political is not there in my copy.
Most probably my book is of 2007.
Oh.
Maybe it has been now amended.
Political has been removed.
আমারটা তো political.
আছে।
So now in my copy, it's literary, scientific and charitable society. The books may be observer dependent also.
There is no noting of any amendment.
In your book, it may read political also. But not in
My book contains political, my lords.
My book does not.
This book is also does not. But we are omitting this.
Political is there.
Yes, may I see my lord's book?
Yes.
My lord
না,
permits.
এটা এখানেও নেই।
This society
আমার তো এক বই।
আপনি কি শেষ দেখ
হ্যাঁ, এখানে the political is there, my lord.
No, this is Cooperative Societies Act.
No, West Bengal
Society
Registration Act.
এটা তো সেন্ট্রালটা দিয়েছেন।
Central, that's the reason Millard is to.
Oh, in West Bengal, it is the central. This was the central act.
Yes, now Millard West Bengal takes over. আছে তোমার copy? আমি দেবো।
Yeah, then your book, yes. So in West Bengal, political is there. Yes, Mr. Bandyopadhyay. An act to provide for registration of such and such society. Yes.
The only purpose of this act is the registrations of the societies because there is no government control as such, my lord, these are private societies.
No, cannot.
My lord, that is why your lordships had also considered, my lord, in a recent judgment of your lordships, my lord, regarding
that-
cancellation of registration. Mr. Srijit Chakraborty probably appeared.
Yes, yes.
Now kindly take, my lord, dissolutions, my lord, there are two provisions, 24 and 25. That is the court's power under 25. This is the civil court's power, my lord. It can be moved by the register or 1/10th member of the, my lord, board.
That is for dissolution.
That is the not only dissolution. Now 23 provides for investigation, but there's no particular actions, my lord, can be taken by the government. My lord, if it is detected, if there is a commission of criminal offense, they can only say that the prosecution be launched. My lord, no actions otherwise can be taken. Now, I'm just reading again, but where on information received, the state government is of the opinion that there are circumstances suggested the business of the society is being conducted with the intent to defraud its creditors, members, or any other person. My lord, this is an actions, my lord, I would say, my lord, this is the executive domain of the state government, which is the discretionary actions of the state government. They may, my lord, or may not.
No, Mr. Bandhavati, you said there are certain judgments which say that it cannot be done on an application of a member.
No. My lord, why I am saying so, 23 does not, my lord, my contention was 23 does not give any legal right to any member of the society or any person that to ask for a mandamus directing the state government that you must consider.
Right.
My lord, like this, my lord, in a income tax provisions, my lord, a complaint, an information is given.
There is no right in their favor which has been infringed. That is your argument.
That is my argument.
If a legal right is not infringed or a constitutional right is not infringed, there is no occasion to issue a rule of mandamus.
Yes.
That was your precise argument.
That on this, my lord, I'll start with, my lord, 1962 Supreme Court, my lord.
You're starting from 1962, so you did not give any hint.
4 judgments.
You could start from 1962.
4 judgments I'll be 60.
4 is already, yes.
Yeah.
One for each of your learned friends, each of your learned juniors.
I'll be embarrassed.
No, Mr. Bandha, please cite. Your contention is that on an application, this cannot be invoked.
There's no provision for applications. My lord, why, my lord, right, my lord, kindly take paragraph 5 of this Constitution Bench judgment, my lord.
Give the citation for
My
Mr.
lord, 1962, AIR 1962, SC 1044.
Para 5, yes.
Para 5, may I read? It's rather longish. The first question that falls to be considered is whether the appellant has locus standi to file the petition under 226. The argument of the learned counsel for the respondent is that the appellant was only managing the industry and it had, well, this is a great case of Calcutta Gas Company. It had no proprietary right therein, and therefore it could not maintain the application. Article 226 covers a very wide power on the High Court to issue directions and writ of the nature mentioned therein for the enforcement of any of the rights conferred by Part 3 or for any fund or for any other purpose. It is therefore clear that the persons other than those claiming fundamental rights can also approach the court seeking a relief thereunder. The article in terms does not describe the classes of persons entitled to apply thereunder, but it is implicit in the exercise of the extraordinary jurisdictions that the relief asked for must be one to enforce a legal right. In state of Odisha versus Madan Gopal Sachansa, this court has ruled that the existence of the right is the foundations of the exercise of jurisdictions of the court under Article 226 of the Constitution. In Charanjit Lal's case, it has been held by this court that the legal right that can be enforced under Article 32 must ordinarily be the right of the petitioner himself, who complains of infraction of such right and approaches the court for relief. We do not see any reason why different principles would apply in the case of the petitioner under 226 of the Constitution. The right that can be enforced under 226 also shall ordinarily be the personal or individual right of the petitioner himself, though in the case of some of the writs like habeas corpus or quo warranto, these rules may have to be relaxed or modified. My lord, this was the law laid down, then the subsequent portion is, my lord, on the particular case. My lord, so there should be a right, and that has been there is an infraction. Yes. My lord, in my
my lord, reading, section 23, my lord, does not give them a right. And there is no question of infractions for, my lord, inviting this court, my lord, to exercise this jurisdiction. Now, the second judgment. Thank you, brother. Thank you. My lord, 1977, 4 SCC, page 145. In fact, in subsequent judgment, this 77 was relied on. Yes. Paragraph 15 of that judgment. 77, 4 SCC, 145. Yes. This is a matter regarding grant of lease. Yes. Kindly take paragraph 15. The contention 3. This contention is also well founded and must prevail. There is abundant authority in favor of the proposition that a writ of mandamus can be granted only in a case where there is a statutory duty imposed upon the officer concerned and there is a failure on the part of the officer to discharge the statutory obligations. The chief function of a writ is to compel performance of the public duties prescribed by the statutes and to keep subordinate tribunals and officers exercising public functions within the limit of their jurisdiction. It follows, therefore, that in order that mandamus may issue to compel authority to do something, it must be shown that there is a statute which imposes a legal duty and aggrieved party has a legal right under a statute to enforce it. But in the other cases, in the instant case, it has not been shown by the respondent that there is any statute or rule having the force of which cast a duty on the respondent number 2 to 4, which they have failed to perform. All that is sought to be enforced is an obligation flowing from a contract with which, well, this is the, well, then I'll be relying on 2008 2 SCC, page 280. Yes. Now, paragraphs 11 and 12 of that judgment. The principles on which a writ of mandamus can be issued have been stated as under in the law of extraordinary legal remedies by H.J. Ferris. H.J. Ferris Jr. Note 187, mandamus at common law is a highly prerogative writ usually issuing out of the highest court of general jurisdictions in the name of sovereignty directed to any natural person, corporation or inferior court with the jurisdictions requiring them to do some particular thing therein specified and which appears to their office or duty. Generally speaking, it may be said that the mandamus is a summary writ issuing from the proper court commanding the official or board to which it addressed to perform some specific legal duty to which the party applying for the writ is entitled of legal right. Note 192, mandamus is subject to the exercise of a sound judicial discretion. The appropriate remedy to enforce a plain, positive, specific or ministerial duty presently existing and imposed by law upon officers and other who refuses or neglected to perform such duty when there is no other adequate and specific legal remedy without which there would be a failure of justice. The chief functions of the writ is to compel the performance of public duties prescribed by the statute and to keep subordinates and inferior bodies and tribunals exercise public functions within their jurisdiction. It is necessary, however, that duty be imposed by the statute. Mandamus lies as well as the enforcement of common law duty. Mandamus is not a right is not a writ of right
Its issuance unquestionably lies in the sound judicial discretion of the court, subject always to the well-settled principles which may have been established by the court. Actions in mandamus is not governed by the principles of ordinary litigations, where the matters alleged on one side and not denied on the other side are taken as true. Judgment pronounced thereon as of course, while mandamus is classed as a legal remedy, its issuance is largely controlled by the equitable principles. Before granting the writ, the court may and should look into the larger public which may be concerned and interest which private litigants are apt to overlook when striving for private ends. The court should act in view of all existing facts with due regard to the consequences which will result. It is in every case a discretion dependent upon all the surrounding facts. Then, my lord, note 206, the correct rule is that mandamus will not lie where the duty is clearly discretionary and party upon whom duty rests has exercised his discretion reasonably within his jurisdiction, and that is upon facts sufficient to support his actions. Next, 12. These very principles have been adopted in our country. Then Bihar Easterns relied on, the second judgment also relied on. Malad 15, I have probably read out, Malad, in the 62 Supreme Court.
Yes.
Then therefore, in order that a writ of mandamus may be issued, there must be a legal right with the party asking for the writ to compel the performance of some statutory duty cast upon the authorities. The last, Malad, I'll be citing, Malad, even for a consideration directions, Malad, one has to show that this legal right has been infringed. That is, Malad, 2007-9 SCC, page 461. Malad, paragraphs 9 and 10. The latter single judge has also issued a writ. Yes. Writ of mandamus directing the appellant to consider the case of the writ petitioner 5 as to whether he was entitled for exemption from the age classifications. As already mentioned, the rules do not make any provisions for granting exemption except to the limited extent as provided in the second para of Rule 11. The principles on which writ of mandamus can be issued are well settled and will refer to only one decision in Bihar Eastern, that is 77-4 SCC. It has been quoted. 10. There being no statutory provisions or rule providing for exemption from eligibility criteria, the Secretary clearly erred in issuing of writ of mandamus against the appellant, directing it to consider the case of the writ petitioner. So that is why, my lord, I said, my lord, this is the discretion exercisable by the executive of the state government. On an information, my lord, they may do so, not do so. But by filing a complaint, my lord, they cannot ask for a writ court, my lord, that you, for a directions upon the state government, my lord, to consider their representations. And this is, my lord, they have stated that they have claimed to be a member, but there is no document attached, my lord, annexed in the writ petitions to show that they are the member of this association. And this, my lord, I leave it to your lordship, my lord. My lord, according to my reading, my lord, I may be wrong, but section 23, according to my reading, my lord, does not give them any, my lord, legal right, my lord, to ask for a mandamus, commanding the state government, my lord, to initiate actions under section 23. Now, that's my reading of the provisions.
You are for the register of firms?
No, I am for the, my lord,
Martial House Owners Society.
Martial House Society, my lord, as per section 19, my lord, it is not a juristic entity, it cannot, my lord, defend or it cannot sue. That your lordships has also held.
Four, yes.
That is why I said, my lord, 4. Right. Represented by secretary, my lord, will not, my lord, cure the defect.
Absolutely. That's below the section.
It should be in the name of secretary representing the society. My lord, a society cannot be represented by secretary because society has no identity. Section 19, if you also kindly see once. And this has been, my lord, I'm not required to cite any judgment. This has been considered, my lord, in various judgment. Suits and proceedings by or against a society. Every society may sue or may be sued in the name of the president, The secretary, in the name of the president or the secretary, not in the name of the society.
Milord, president is there. What he is saying, Milord, they refer.
No, I say, Milord, 3.
4 is, Milord, the president
Four,
of
that is
martial
why
house.
I
Milord.
said that I am representing 4.
Milord, then he can't say the writ is not maintainable. I have to make him a party. That's all.
Milord, your lordship's question was different, Milord, I
He
answered.
doesn't say that it is not maintainable on that ground. He says he cannot represent 3 on that ground.
3 is a party, Milord. It's a
Your only prayer in the writ petition, you are restricting it to a consideration of.
I am a consideration. Our prayers are, Milord, for various things, but for the, if there is a, there should be a, Milord, kindly, Milord, takes the act once, Milord. 2-3 sentences. The state can take this point by learning. There's an ad hoc committee. Milord, today the ad hoc state can come, Milord, and raise the issue of notice. Today, Milord, the ad hoc committee, Milord, perhaps cannot take the point of locus here. It's a duty of the state. State can come. There is a representation, however, or a letter, however, dealt with the letter. Milord, if your lordship kindly takes, Milord, the act once, 2 sentences, and Milord, 2 orders I'll show. Milord, under section 21, Milord,
yes,
a member is liable to be sued or prosecuted as strangers by the society in case of defalcation of funds or any Milord things done against the society. So, Milord, a member can be sued by the society itself. So far as 22 is concerned, there's a difference in the language. The power of the registrar to call for information and explanation. This does not say, unlike section 22, that on information being received. So, Milord, this is not a, Milord, suo motu action. Someone gives an information to the state, unlike, Milord, section 22, where there the registrar, Milord, suo motu by a written order can do. But in section 23, where on an information received, the state government is the opinion that a circumstance suggesting that the business of the society is being conducted in a manner to defraud creditor, members, or any other person, or the society is guilty of mismanaging the affairs of or of fraudulent or unlawful act, the state government may appoint a competent person, commissioner of inquiry, to investigate into affairs of the society, inspect institute managed by the society, and report such matter to the state government may direct.
Yes.
So, Milord, it's on a complaint or on an information by way of a letter or anything, Milord. Now, Milord, with the intent to defraud the creditor, members, or any other person. So there is the locus. So any other person, Milord, any person can come. Milord, I do not say it should be wholly a stranger. Milord, the locus today, Milord, is a person aggrieved, Milord, a person interested, and a stranger's writ petition. This is the locus today as we stand, Milord, in the today's society, Milord. So, Milord, this is my complaint. Milord, I have given 2 complaints, Milord, alleging what? A, defalcation of funds. The FDs from, Milord, 80 lakhs have been reduced to 9 lakhs. There is a bad debt of 1 crore in the society, not recovered. There is, Milord, an auditor's report saying, Milord, no annual general meeting, no accounts filed, there is no balance sheet, Milord, nothing. Everything is in dark. So, Milord, I raise a complaint, which is, Milord, at page 102, Milord, 112 and 120 are the 2 complaints. I ask, Milord, for inquiry in the matter. Milord, so, Milord, there is a legal right of a member to know, or legal right of a allottee to know. I am a allottee. Now, Milord, just one judgment I show for this, Milord, on the locus, since my learned friend has placed. 2002, 1 SCC, page 33. Kindly have the view and the recent view, Milord. Kindly have a look at para 38 only. Page, I had a copy though, Dada. Page 38. In inside. There is no dispute, para 38, regarding legal proposition that the rights under Article 226 of the Constitution of India can only be enforced by a aggrieved person, except in the cases where the writ is for habeas corpus or quo warranto. Another exception is the general rule in filing the writ petition in public interest. The existence of a legal right of a writ petitioner which is alleged to have been violated is the foundation of invoking the jurisdiction of High Court under the aforesaid article. The orthodox rule of interpretation regarding the locus of a person to reach the court has undergone a sea change with development of constitutional law in our country, and the constitutional courts have been adopting a liberal approach dealing with the case for dislodging a claim of a lady merely on high court technical ground. If a person approaching the court can satisfy the impugned action is likely to adversely affect the right, which is shown to have been some statutory provision, the petition filed by a person cannot be rejected on the ground of not having locus standi. In other words, if a person is found to be not merely a stranger having no right whatsoever to any post or property, he cannot be non-suited on the ground of not having locus. Here am I allotting. Milord, page 32. It's recorded. Page 32. Milord, members, Milord, WhatsApp chat, Milord, have been included ad hoc committee functioning. They don't want an inquiry today. And Milord, in these circumstances, there's a higher order passed, Milord, by a coordinated bench appointing an auditor. I'm not wanting that, Milord. I want my representation to consider. The state is here, Milord. Lordship can call upon the state. Kindly have a look at, Milord, Justice Boshak's order, Milord. If there is no accounts, no balance sheet, no filing of the accounts, Milord, auditor is a matter of course. Milord, I have watered down my prayer. This is the coordinate bench's judgment, Milord. And Lordship's judgment, Milord, Lordship has construed order, say, section 23, Milord. What it means, Milord, I am not citing it, Milord. Since Lordship has done 32 paragraphs, Lordship has to write on that. Suitable auditor plus, Milord, the inquiry will, if the state wants, state can proceed, Milord, whatever they want to do. Because there is already an auditor's report. The auditor says there's a defalcation of funds.
Well, yes.
These are my
These judgment, my lord,
State wants, who is appearing for the state?
I'm appearing.
What is your stand?
Lord, so far as the allegations are concerned, Milord, if Milord will kindly take up the allegations.
Allegations in the representation?
Representation or Milord, that is
Whatever, yes.
representation.
About
Milord,
that what?
Those allegations are pursuant to non-filing of IT returns, so far as not payment of provident fund dues are concerned, Milord. Milord, there are, I would not say, Milord, though I do not have instructions to say particularly from the respondent number 2, Milord, but I would not be able to say that we will not consider if Milord directs. However, Milord, if the provident fund is not being paid, if the income tax returns are not being filed, Milord, perhaps there are other remedies available as well. Because, Milord, those are matters which has to be dealt with in separate acts at the same point of time, Milord. But the allegations which says that the income tax returns are not filed, provident funds are not getting paid, audits are not being made, there are matters of financial defalcations, Milord. Those are broader aspects. And perhaps, Milord, though there are laws which Mr. Bandyopadhyay has cited, Milord, saying that the courts will not interfere so far as directing of a consideration, or that, Milord, perhaps right now I am not in a position to assist, Milord, whether the petitioner has a right so far as being a member of the society or not, Milord. That is Mr. Bandyopadhyay's prerogative to assist the court so far as that aspect is there, Milord. But so far as the allegations are concerned, Milord, those are wide. And Milord, if Milord takes up the prayers, in each of the prayer, Milord, the petitioners have sought for investigation, has sought for inquiries, Milord. Milord, whether Milords will allow for a holistic inquiry or an investigation, Milord, that is also perhaps.
Let them take a decision. On the first day, I said, Milord, let them, if Milord decision against me, I have a right to come to court. If it is in my favor, Mr. Bandyopadhyay will be in court.
Milord,
but
we have to take a decision, Milord. Let's see maintainability, whether they have the right to maintain the complaint or not, Milord. That also be given to us a power.
That we have argued, Milord.
And that can be urged, Milord, keeping all the points.
That I said, Milord.
If
now
it is a simplicity consideration order.
That is the first thing he said.
Milord, if it is a simplicity consideration prayer, Milord.
So, Bandyopadhyay, any answer to the
Milord,
judgment cited?
No objections has been raised, Milord, with regard to the maintainability of the writ petitions or the power of the court, Milord. As I raised, Milord, you will not find any such objection.
Said,
so,
Milord,
court is not never invited, Milord, to adjudicate on that issue.
There are at least, Milord,
simplicity
12
directions.
12 consideration orders.
Without considerations, Milord.
There are, Milord, 12.
There may be 2-page considerations order. If these objections have not been taken, Milord, this cannot be, Milord. This is a age-old, starting from Manasnath Rai's judgment, what would constitute precedent?
Milord, I have a site.
Policy is well aware.
Milord, I have cited a judgment which said
Which would
I
be the
should not be a
precedent.
stranger. That's all.
Milord,
Milord.
if there is no issue is there, no adjudication on
Milord,
this
he
issue
can't
is
take
there,
this.
Milord, it cannot operate as a precedent.
Milord, why my learned friend is apprehending, Milord? That the investigation will be against him.
I am apprehending in a broader aspect. The
Kindly take
owner
page
said what
72.
rejections,
Milord, page 72. The
against our
backdates is one crore.
predecessors. And without making us party, this execution proceeding is going on. This association is vehemently objecting to the execution, which will result in vacating of the property by 800 occupiers. That particular these petitioners must be coped in by the owners.
These are all apprehension, Milord.
That's act order record.
Kindly, Milord,
This
record.
side,
Kindly take.
If I hold in favor of them, if I dismiss on the ground of maintainability, then no question of anything else. If I hold on the ground of maintainability, if I admit his writ petition, I'll dispose it up by directing them to consider. I'm just doing it right now. At the outset, learned counsel for the respondent number 4 seeks to raise an objection as to whether the petitioner has locus standi to maintain the present writ petition. First up, it is argued that no legal right has been vested under section 23 on the petitioner to file a writ petition. First up, it is argued that no legal right has been infringed in the present case to vest the court with the power under Article 226 of the Constitution to issue a writ of mandamus. First up, next para, in support of his arguments, learned counsel for the respondent number 4 cites the language of section 23 of the West Bengal Societies Act 1961, West Bengal Societies Registration Act 1961, which opens with the words within double inverted, where on information received, the state government is of opinion, ... double inverted close. First up, next para. Learned counsel for the respondent number 4 cites a judgment of the Supreme Court, cites a 5-judge bench decision of the Supreme Court reported at AIR 1962 SC 1044. First up, in the said case, the Supreme Court had observed that Article 226 confers a very wide power on the High Court to issue directions and writs of the nature mentioned therein for the enforcement of any of the rights conferred by Part Roman 3 or for any other purpose. First up, however, in the same breath, the Supreme Court observed that it is implicit in the exercise of the extraordinary jurisdiction that the relief asked for must be one to enforce a legal right. First up, next para, the Supreme Court further observed that the right that can be enforced under Article 226 also shall ordinarily be the personal or individual right of the petitioner himself. First up, next para. Learned counsel next cites another judgment of the Supreme Court reported at 1977 4 SCC 145, where the Supreme Court observed, inter alia, that a writ of mandamus can be granted only in a case where there is a statutory duty imposed upon the officer concerned, and there is a failure on the part of that officer to discharge the statutory obligation. First up, it was further held that in order that mandamus may issue to compel the authorities to do something, it must be shown that there is a statute which imposes a legal duty and the aggrieved party has a legal right under the statute to enforce its performance. First up, next para. Learned counsel then relies on Oriental Bank of Commerce versus such and such, reported at reported at 2012, sorry, 2012 দেবেন না, 2008 2 SCC 280. Full stop. In the said judgment, comma, the Supreme Court observed, comma, inter alia, comma, that the principles on which a writ of mandamus can be issued had been stated in the law of extraordinary legal remedies by F full stop G full stop Ferris, Ferris, and FG Ferris, একই নাম, comma, junior, which have been adopted in our country. Full stop. Next para. It was inter alia observed, comma, while quoting from the said work, comma, that mandamus at common law is a highly prerogative writ, usually issuing out of the highest court of general jurisdiction in the name of the sovereignty, comma, directed to any natural person, comma, corporation or inferior court, comma, addressed to perform some specific legal duty to which the party applying for the writ is entitled of legal right to have performed. Full stop. The chief function of the writ is to compel the performance of public duties prescribed by statute. Full stop. Mandamus, comma, it was observed, comma, is not a writ of right. Full stop. Its issuance unquestionably lies in the sound judicial discretion of the court, comma, subject to the well-settled principles established by the courts. Full stop. While mandamus is classed as a legal remedy, comma, its issuance is largely controlled by equitable principles, and before granting the writ, comma, the court may and should look to the larger public interest which may be concerned. Full stop. Next para. Thus, comma, it is argued, comma, the present writ petition is not maintainable at the behest of the petitioner, whose right as a member, comma, in any event, comma, has not been established by any cogent document. Full stop. Next para. Learned counsel for the state adopts the argument of respondent number 4 as to maintainability at the behest of the petitioner, and further submits that even from the representations annexed to the writ petition, comma, the nature of complaints of the writ petitioner are disclosed, comma, which regarding which the relief of the writ petitioners may lie before the appropriate statutes, but not under section 23 of the Act of 1961. Full stop. Next para. In any event, comma, it is contended that the state does not, comma, in principle, comma, have any objection, comma, if directed by the court, comma, to look into the issues, comma, subject to the above submissions. Full stop. Next para. Learned counsel appearing for the petitioner, comma, in reply to the question of maintainability, comma, cites a judgment of the Supreme Court, in Ghulam Qadir versus such and such, reported at 2002 1 SCC 33, comma, in which the Supreme Court had observed, comma, inter alia, that there is no dispute regarding the legal proposition that the rights under Article 226 can be enforced only by an aggrieved person, except in cases of habeas corpus or quo warranto. Full stop. The existence of the legal right of the petitioner, which is alleged to have been violated, is the foundation for invoking the jurisdiction of the High Court under the said article. Full stop. While further commenting on the issues, comma, the Supreme Court observed that the orthodox rule of interpretation regarding the locus standi of a person has undergone a sea change with the development of constitutional law in our country, and constitutional courts have been adopting a liberal approach in dealing with cases or dislodging the claim of a litigant merely on hypertechnical grounds. Full stop. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right, which is shown to be having source in some statutory provision, comma, the petition cannot be rejected, rejected on the ground of lack of locus standi. Full stop. Learned counsel also places reliance on a coordinate bench judgment of this court, comma, where the learned single judge had passed an order on a higher footing than the present case, comma, insofar as the court had appointed auditors to look into the affairs of a society. Full stop. It is submitted that in the present case, comma, the petitioner only chooses a consideration of its complaint by the state government under section 23 of the 1961 Act. Full stop. Next para. On the question of maintainability, comma, on the question of locus standi of the petitioner, comma, the judgments cited by the parties are uniform on the aspect that a writ of mandamus can be issued only when there is an infraction of a legal right. Full stop. The infraction of a legal right, comma, as harped on in the judgment of Calcutta Gas Company Supra, comma, has further been elaborated in the subsequent judgments cited by the respondent number 4 as well. Full stop. Next para. In paragraph 15 of Bihar Eastern Gangetic Supra, comma, the Supreme Court elaborated on the issue of infraction of a legal duty. Full stop. While doing so, comma, it was observed that a writ of mandamus can be granted only in a case where there is a statutory duty imposed upon the officer concerned and there is a failure on the part of that officer to discharge the statutory obligation. Full stop. The chief function of a writ was held to be to compel performance of public duties prescribed by statute. Full stop. In such context, comma, it was held that it has to be shown that there is a statute which imposes a legal duty and the aggrieved party has a legal right under the statute to enforce its performance. Full stop. Next para. Insofar as Tirumala Tirupati Supra is concerned, comma, the same principle was reiterated. Full stop. The court echoed, ECHOED, echoed the observations in Bihar Eastern Gangetic Supra while holding that there is a statutory duty imposed upon the officer concerned and there is a failure on the part of the officer to discharge the statutory obligation is sufficient to invoke the writ jurisdiction and issue a writ of mandamus. Full stop. Next para. In Oriental Bank of Commerce Supra, comma, the Supreme Court went one step further and also considered the observations made in the law of extraordinary legal remedies. Full stop. Next para. It was held that the very principles had been adopted in our country as well. Full stop. Next para. A scrutiny of the excerpts from the said book quoted in paragraph 11 of the judgment, comma, indicate that the chief function of the writ is to compel the performance of public duties prescribed by statute. Full stop. It was further observed that mandamus is not a writ of right. Full stop. Its issuance unquestionably lies in the sound judicial discretion of the court, comma, subject to the well-settled principles established by the courts. Full stop. Mandamus, comma, it was observed, comma, is classed as a legal remedy, but its issuance is largely controlled by equitable principles, comma, looking to the larger public interest which may be concerned. Full stop. In fact, comma, it was observed that an interest regarding larger public interest, no, an interest, no. It was observed that a larger public interest is often overlooked by private litigants when striving for private ends. Full stop. Next para. Read in appropriate context, comma, the above judgments clearly lay down that there are two vital components to the exercise of the writ jurisdiction while issuing a writ of mandamus. Hyphen, the first, comma, a statutory duty being imposed on an authority, and second, comma, the infringement of the legal right of the applicant. Full stop. Next para. The infringement of a legal right may be of different shades and types. Full stop. Next para. As observed in the judgment of Oriental Bank of Commerce Supra, comma, a legal right may be said to be infringed when the said legal right flows from a statute and imposes a statutory duty upon an official, comma, which has not been properly undertaken by the said official. Full stop. An element of public duty has to flow from the duty so cast by the statute. Full stop. Taking a proper look at the language of section 23 of the 1961 Act, comma, which is the subject matter of consideration in the instant case, comma, the very opening lines of the said section speaks about the following, colon diye, double inverted, where on information received, comma, the state government is of opinion that there are circumstances suggesting that the business of a society is being conducted with intent to defraud its creditors, comma, members or any other person, comma, or that the society is guilty of mismanaging its affairs or of any fraudulent or unlawful act, comma, the state government may appoint a competent person as commissioner for inquiry, CRETA capital, to investigate into the affairs of the society or inspect any institution managed by the society and report on such matters as the state government may direct. Full stop. Next para. Subsection 4 of section 23 stipulates that on the conclusion of the investigation or inspection, comma, if directed, comma, the commissioner for inquiry shall make a report to the government on the matters on which he was directed to report. Full stop. A penalty is imposed on the officer in case of default to file such report. Full stop. Subsection 6 provides that on perusal of the report, comma, the state government may give such directions as it may think fit to the society for the removal of any defects or irregularities within such time as may be specified, and on the society making any default, comma, the state government may direct the registrar to move the court for dissolution of society. Full stop. If on a perusal of the report, comma, as per subsection 7, comma, the state government is of the opinion that any person has in relation to the formation, comma, promotion, comma, management or conduct of the business of the society, comma, being guilty of any offense for which he is criminally liable, comma, the government may direct the prosecution of such person for the offense. Full stop. Next para. Sections 24 and 25 deal with dissolution, comma, respectively by resolution and by the court. Full stop. Next para. Hence, comma, A comprehensive perusal of the scope of section 23 indicates that the same culminates in a recommendation by the a direction by the society for action to be taken before a civil court for dissolution of the society and comma if necessary comma for criminal prosecution. Next para, both the said both the said outcomes directly affect the interests of members, comma, allottees, and other interested persons with regard to a society. Next para, read in such context, comma, the judgment of Ghulam Qadir Supra cited by the petitioner acquires importance. In the said judgment, comma, the Supreme Court was discussing the evolution of the concept of locus standi in the constitutional writ jurisdiction. It was observed that the orthodox rule of interpretation regarding locus standi has undergone a sea change with development of constitutional law, and constitutional courts have adopted a liberal approach in dealing with cases or dislodging the claim of a litigant on hypertechnical ground. As observed in paragraph number 38 of the said judgment, comma, in the present case, the person approaching the court has prima facie satisfied that the impugned inaction of the state in not looking into and forming an opinion under section 23 on the complaints made by the petitioner is likely to adversely affect the petitioner's right as an allottee and a member, which has its source in a statutory provision in the form of section 23 of the 1961 Act. Section 23, comma, in fact, comma, casts an obligation of the state government to consider information, comma, in whatever form it reaches the state government, comma, to form an opinion thereon as regards the criteria stipulated therein. The expression within double inverted information received, double inverted clause, may also be in the form of a specific complaint lodged by a member of a society, comma, an allottee of a society, or in some cases, comma, even a third party stranger having some interest in the functioning of the society. In fact, comma, section 23 within bracket 1 is wider than the above interpretation, inasmuch as it does not distinguish between an information in the form of a complaint from a stranger or a member of the society or even any interested person. Next para. In the present case, comma, it is not in doubt that the petitioner has raised certain serious complaints regarding the functioning of the society, comma, which might or might not culminate in the options as enumerated in the last few subsections of section 23 of the 1961 Act. Next para. Insofar as the citation of Chandan Chakraborty Supra is concerned, comma, however, comma, I am not satisfied that any ratio was laid down therein regarding the locus standi of the petitioner. In the said case, comma, the writ petitioner had approached the court with regard to non-completion of accounts in respect of a registered society. The erstwhile precedent therein had been proceeded against for defalcation of funds of the society. The relevant documents for completion of such accounts were with the society. In such circumstances, comma, necessary orders were observed by the court to be issued directing the registrar to appoint an auditor to prepare such accounts, comma, etc. Since the court was of the opinion that in the circumstances the registrar was to appoint a suitable auditor or auditors, comma, the matter was not restricted to the limited question of locus standi, comma, nor was the issue of locus standi or any objection in that regard raised, comma, as rightly pointed out by learned counsel for the respondent number 4 in the present case. Full stop, next para. However, comma, in view of the discussions made above, comma, the petitioner definitely has a locus standi to point out to the court the inaction on the part of the state government in adverting to the complaints lodged by the petitioner by treating the same to be information received within the purview of section 23 within bracket 1 of the 1961 Act, and to form an opinion, comma, on reasons ascribed by the state government, comma, as to whether there are circumstances suggested in the within the contours of section 23 of the Act. Full stop. Hence, comma, the objection as to locus standi is turned down. Full stop. The writ petition is entertained. Full stop. In view of the prayer of the writ petitioner being innocuous, comma, WPO 1504 of 2023 is being decided without directing affidavits, comma, of course, comma, with the rider that it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop. WPO 1504 of 2023 is, comma, thus, comma, disposed of by directing respondent number 1, comma, the state of West Bengal, comma, to decide on the complaints lodged by the writ petitioner with regard to the functioning of the cooperative society in question, being the Marshall House Owners Society, comma, in terms of the representations annexed at pages 112 and 123 of the present writ petition. Full stop. It is expected that such consideration, such exercise will be completed by the state government within 4 weeks from date, and a decision shall be taken by the state government as to whether it is of the opinion that the subsequent clauses of section 23 of the 1961 Act after subsection 1, comma, would be invoked or not. Full stop. The outcome of such consideration shall be intimated by the respondent number 1 in writing, both to the petitioner as well as the respondent number 4 and also the concerned cooperative society.
Owners society. It should be owners.
Immediately
Marshall
thereafter.
House,
Not
Owners
cooperative
Society.
society.
Not cooperative society.
Marshall
Not
House,
cooperative society.
Owners Society.
The concerned registered society within cooperative that registered with. Yes.
Only two submissions. One is that the 4 weeks may start from the date of the communication of the order. Let that
You are the communication.
Another is
Your presence is the communication.
Respondent number 1 is the state. Let the direction directly be upon the secretary. Because all these.
Which respondent?
There is not a party.
State is all comprehensive. Yes.
Not because Millard has directed the state again to communicate. Millard, if the secretary is directed, Millard, all the representations.
State will communicate. Everything is a state. If the state does not, you will.
Great.
Yes, বইটা ফেরত হবে.
Grateful to you.
Thank you.
Obliged, Millard.
না ভালোটাও দে, খারাপটাও। Thank you. Sorry. হ্যাঁ, এটা নাম বলে দাও। Pardon?
Grateful, my lord.
Thank you. So.
This required an adjudication.
No, it required because the time and again these are this will go on. Yes. Thank you.
Grateful.
Next.
Item number 2 for hearing, Alpha Stitch Art Private Limited and another versus this West Bengal Small Industries Development.
Yes. You are for Alpha?
Yes.
You are for numeric? Yes,
For
Mr.
beta, my lord. My lord, your lordship had heard this matter earlier. It might come back to your lordship, my lord.
Right.
My predecessor in interest, I just give a primer, my lord, since I'm in reply. Mr. Chorus, my learned senior friend, has concluded his arguments.
Yes.
My predecessor in interest was the lessee of a plot of land allotted by the respondent corporation, my lord. The lease was cancelled. The proceedings, I challenged that proceeding. The lease was cancelled. There's a provision of an appellate authority. I applied to the appellate authority. The lease was not reinstated. I came up before this honorable court. The honorable court granted a stay. The writ court at the first instance granted a stay. Against that ad interim order of stay, the corporation went up in appeal. the appeal was not only dismissed, the writ was allowed. The appellate court allowed the writ at the stage of the appeal. From that, the corporation preferred an appeal before the Supreme Court. During the pendency of the appeal before the Supreme Court, my predecessor in interest entered into a scheme of amalgamation with 5 other companies. This was at the stage when the Supreme Court appeal was pending. By virtue of that scheme of amalgamation, which was with me also, we are all group companies, 6 companies of the same group entered into a scheme of amalgamation. My predecessor in interest was one of those companies. I am the petitioner, the transferee company. They were the transferor companies. By virtue of that scheme of amalgamation, my lord, the leasehold right, which if was sustained by the Supreme Court, would stand vested in me by virtue of the scheme of amalgamation. Of course, it would not be binding on them, but thankfully they have not taken that ground. They have not said that we do not accept this transfer by way of amalgamation. What they now say when I apply, now after the Supreme Court order, by which the division bench order of our court was sustained, my lord, I applied to them that please record the transfer of lease in my name pursuant to the scheme of amalgamation sanctioned by the the NCLT, Calcutta bench. They write back saying, give me your documents, which would show that you're part of the same group of companies, same promoters, same directors, same shareholders. I gave that because that is where the whole catch is, my lord. There is a scheme of WBSIDC. The scheme is that if you are part of the same shareholding, your shareholding doesn't change between the transferor and the transferee company upon sanction of a scheme of amalgamation, the WBSIDC does not treat it as transfer, and they will not charge transfer fees, with the caveat that permission for entering into this scheme should be obtained prior to entering into the scheme. That is the only caveat. But in the eyes of WBSIDC, if the transferor and transferee company have the same management and have the same shareholding, then they do not treat it as a transfer. It is a transfer in law, yes, but for WBSIDC, it does not attract transfer fee. Only charge of 10,000 is payable. That is their own scheme. The only condition there being prior permission.
Yes.
I had placed before your lordship, I could not have, even if I would have obtained, no prior permission would have been granted, because according to them, the lease stood terminated on the day I entered into the scheme. And the scheme was not only for acquiring this leasehold asset, it was a scheme of 6 companies. Scheme was not designed only for one company or just to take this asset. So, my lord, now it is undisputed that I have, my lord, it is not controversial. I've given my CA certificate, and they also accept the fact that yes, your shareholders are the same. The recordings to that effect are there also in the NCLT order, that the shareholders and directors are by and large the same.
What was the date of the amalgamation, Mr.
Yes,
Thakur?
my lord, the date of the amalgamation order.
Only that.
5th March 2020 is the date of amalgamation order. The appeal, my lord, I'll just give your lordship 3 dates if your lordship permits me, my lord.
Yes.
The lease was terminated on 9th November 2013.
Yes.
29th January 2014.
The petition and stay.
The writ court stayed. Your lordship has the dates. I'm sorry.
The-
The writ court stayed, my lord. The appeal was preferred.
What happened on 16th of January 2014? I can't read my own
16
handwriting.
I'm sorry.
No, but I should be sorry because I can't read my
16th of January 2014.
Something happened. If it's not important, leave it. Something was upheld probably. That much I can decipher.
16 January 2014.
Appellate
Yes,
authority
yes.
upheld,
Appellate authority would have upheld, my lord.
What appellate authority upheld?
The appellate authority under their act, my lord, the Land Act, the West Bengal Premises Act. They went under the West Bengal Premises Act. The primary ground of challenge was it could not have been terminated under the Premises Act. They should have gone under the Land Act.
That is not so important. I
Yes,
think.
that is not so
Leave it,
important.
leave it,
So my lord, the termination
29th
is
January.
9th November 2013. That is the notice by which they terminated.
29th January 2014, the writ petition moved and the stay was obtained.
Stay was obtained. Now the appellate court, my lord, dismissed the appeal, allowed the writ petition on 19th September 2014. 19th September 2014 is our division bench order.
Yes.
From which, my lord, an appeal was preferred and instantly the appeal was admitted. It was numbered as a civil appeal of 2020. Now, during the pendency of this appeal, my lord, 5th March 2020, my scheme of amalgamation came to be sanctioned. 18th March 2020, the Supreme Court dismissed the appeal.
But Mr. Thakkar, as of, I mean, from 29th of January 2014.
Yes,
I mean, that was only a stay.
that was only a stay.
But at least from when the date from when the writ petition was allowed, I mean, the division bench allowed.
Division
From
bench.
that date, this argument does not apply that you could not have taken prior permission of them. Because at that point of time, by court's order, the
Yes.
lease was surviving.
The lease was restored. Yes.
Rather restored.
Yes.
So there was a lease.
There was a lease.
So why do you say, how can you say that you could not have informed them?
My lord,
Because there was no lease.
I could have informed them, but it would have been an idle and empty formality, given the fact that they were challenging the order of the court.
It was their challenge.
It
but
was
in
their
law, it was there. From your perspective,
From my perspective, I could have informed.
there was no fetter on you.
Yes, there was no fetter
There
on
could have
me.
been a fetter on them to accept.
Yes.
But you never tendered, never gave the information.
I never gave the information. That is right.
So that
On
should not
fact-
compass, yes.
Yes, on fact, that is correct, my lord. On facts, that is correct. But your lordship
It
takes
is technical, but it is there in the scheme.
Yes, it is there. Now, my lord, what is the consequence of not complying with that? What is the consequence of not complying with that? That is the test, my lord. My learned senior friend has taken your lordship through the provisions of the Transfer of Property Act. I was not there, but now with this live streaming, my lord, this is a big advantage. So, my lord, my learned friends made notes, but I could see the arguments, my lord, on live stream later.
Right.
So, your lordship was taken through the provisions of 106J of the Transfer of Property Act that prior permission has to be taken. And your lordship was also shown clauses J and L of my lease deed, which also say prior permission is required to be taken. Apropos this, although this is not very relevant in my respectful submission, given the scheme, what is now for consideration is the scheme.
Yes.
What is now is the scheme. Your lordship has to consider what is the scheme, what is the object of the scheme, what is the reason why the scheme came in. The elaborate discussions are there in their own board minutes. They took opinion from a solicitor of our court, and they took opinion from a trade body, Bengal Chamber of Commerce, and a solicitor of our court.
Yes.
And both opined that for the progress of trade and industry, this should not be done. If it's a partnership, if the constitution stays the same, if it's a company, the shareholders, directors stay the same. That is why, my lord, why they did this. Because my learned friend has shown your lordship two judgments of our court of 2015 and 2018. Identical.
Yes.
One judgment of my Lord Justice Boshak and one judgment of 2018.
Yes.
I'll tell you, I'll just give you a lordship. Three judgments were shown by my learned senior friend.
Three judgments. One of 2017 also.
One of 20. Sorry?
I mean, one is no 2010 probably. But 2010 was your judgment.
My lord, one reported in 2017 of my Lord Justice Boshak, Man Concast.
Yes.
Man Concast and Allen B. Garments of 2018, not 2015. Division bench, Allen B. Garments.
2018, yes.
Yes. My lord, I was very scared when I went through these judgments, but then I saw that none of these judgments consider the scheme because the scheme wasn't there. The scheme is of 2019. That is why when your lordship goes through these judgments, your lordship will not find any reference to this scheme which my learned senior friend has disclosed in his opposition. Otherwise, the facts are bang on. I am squarely covered by these judgments, except for the fact that none of these judgments consider the scheme because the scheme wasn't there.
If the clauses were similar, the
Identical. But these judgments only consider the point that this is a transfer. The Ghulam Qadir, Singer, all of them say it's a voluntary transfer between two companies. The operation of law argument does not lie without the consent of the landlord. Therefore, it's a transfer. It's a device by which the scheme of amalgamation is a device by which property is transferred inter vivos. And therefore, if you're transferring the identity of the tenant, you need, if the tenant is transferring his identity to somebody else, there's a new tenant coming in, then you need the consent of the landlord. Otherwise, it amounts to subletting. That is the principle which is followed on here. But that principle in my respectful submission, and therefore transfer fee payable. The argument was that this is the operation of law, vesting by operation of law. It was answered that no, even if it is operation by vesting of law, it's a transfer, you have to pay the transfer fee. But that is before the scheme came in. And the scheme is the game changer. Otherwise, I'm squarely covered by these two judgments. Now, these two judgments are not an authority for the proposition that what happens if you don't take prior permission envisaged in the scheme.
No, not that. Not that. On that, these cannot be provisions.
These cannot be.
How do you get over that provision of the?
Now, my lord, kindly see the, now, so therefore, my learned senior friend perhaps relied on 106J of the Transfer of Property Act to say that this was is there in law also. This is always there in law, but the consequences of not following the lessee's obligation in 106J, I'm sorry, 108J, is
Need not be, yes.
He cannot be, my lord, anything, because then it has to be provided in 111. Kindly see now 111 of the Transfer of Property Act. You cannot determine unless there's a clause of forfeiture for breach of this particular condition given in the lease document. And the lease document does not say this to be a ground of forfeiture. Kindly see the lease. The lease document squarely considers this provision and says that the right of re-entry and forfeiture of lease does not include this. Kindly see, my lord, page. The lease starts at page 42. And the forfeiture clause is at page 53A. So J was shown to you, I'm sorry, I should show your lordship J, not to sublet, assign or part with possession of the demised premises or part of it, or transfer without the permission, on transfer without the permission of the lessor, for which subletting transfer fee will be charged as may be applicable. From the clause itself, it would show that even if the lessor gives permission, you will still have to pay transfer fee. Two clauses were shown to your lordship, subject to correction, J and L. Kindly see J and L at page 48-49, please, my lord.
So now the present problem boils down to this transfer fee charging.
Transfer fee charging, applicability of the scheme, because your lordship sees at that when the lease was, because lease was entered into earlier in point of time. Their own policy came much later. So now the lease contemplates, kindly see, not to sublet, assign or part with possession of the demised premises or part of it on transfer without the permission of the transfer of the lessor, for which subletting or transfer fee will be charged as may be applicable. There is no absolute bar. You take my permission.
It's couched in a previous peculiar language.
Yes, but it makes kindly see 49. To be fair to my learned senior friend, because he showed 49 also.
Yes.
Not to enter into partnership with any person or to change the identity or character of the lessee. This is what will apply, identity or character of the lessee, without prior written consent from the lessor. Now, in case of change of identity or character, the lessee will be liable to pay transfer fee at the rate as decided by the lessor from time to time. So two things come out from this clause. One, when we read them together, the first sentence and the second sentence, not to change without prior consent. And if there is a change of identity or character, you have to pay transfer fee. Now, I'm going to kindly see the forfeiture clause 3A. Does not provide that if you transfer possession without my prior consent, the lease shall stand forfeited. At page 50. So the veiled threat given in paragraph 21 of the opposition that I am doing you mercy by charging you transfer fee, otherwise I was entitled to forfeit, perhaps is not correct, neither under 111 nor 3A.
The language, as it has been couched, page 49 indicates that in case of change of identity of character or character, in any event, whether it is before with consent or not consent, you are liable to pay.
Liable to pay transfer.
Apparently, that can be a valid.
Yes, my lord, because the consequence of not taking prior consent has to
that
be
has not been stipulated.
That has not been stipulated.
There is no sanction here.
There is no element of sanction. This is just by way of abundant caution. I must know you are going out. Who is coming in? I must know. Now I can withhold permission. But you will remain. And if you leave without my permission, it doesn't say I can revoke. Kindly see 3A. It's a rather longish clause. It is expressly agreed by and between the parties.
But there is nothing regarding the breach of any condition, any of the conditions.
No, the omnibus clause is not there.
Nothing is there.
No, subject to correction, it's not there, my lord. 50 and 51, your lordship will go through it, please, my lord. The omnibus clause, breach of any condition will lead to, it's not there.
Quite surprised.
Now, my learned senior friend will take a note and include it. He's not here, but
in the next case.
In the next, when they give the lease. Your lordship will go through 50, 50, it's not there.
That's a very rule. That is somewhat strange, yes.
So now, Malad, kindly see now their own policy. So, Malad, the first two judgments of our court, Malad, perhaps do not apply because they do not consider the policy, which is a subsequent event. And they can't, it's not their case that they are not bound by the policy because they have themselves very fairly disclosed the policy, which I would not have otherwise access to. Starts at, Malad, kindly see page 18, please, Malad. I've shown this earlier, but for the sake of conclusion, Malad, may I just show? This is the minutes of the 353rd meeting at page 18. The agenda, kindly see agenda item now, agenda item number 19-353 at
Page 18 of?
Page 18 of their opposition.
I'm sorry, yes. Yes.
Page 18 of their opposition. This is the agenda. So first, Malad, they have this agenda of the board of directors meeting. Page 19, agenda item 19-353. Recently, so-and-so and so-and-so have given their recommendation regarding transfer and surrender of lease. They suggested that following may not be considered to be transfer by the lessor upon examination of the application for prior intimation made to the lessor for the same by the lessee. 1 and 2 don't apply. Kindly come to 4 straight away, Malay. Merger, arrangement and amalgamation of the lessee within its group company. Any other corporate action which does not lead to change in control. And then a certificate from a chartered accountant certifying whether any transfer is a transfer or not. Then the transfer shall not be done. If there is a transfer, then there is then the next stage comes in. The transfer.
What does this mean, Mr. Thakur, according to you? Coming back to page 19.
Yes,
they suggested that the following may not be considered to be transferred.
Need not.
By the lessor.
Yes.
Yes.
So, these are
only upon examination of the applicants for prior intimation made to the lessor for the same by the lessee.
This language, yes. Well, perhaps
what
they
is
are.
your take on this?
To be fair, they say that this only upon examination of the application by prior intimation or upon prior intimation being given by the lessor to the lessee.
What is this application for? That application giving the intimation.
Giving the intimation.
Right.
That I propose to enter into this arranged scheme, or I propose to enter into this, but this is not a transfer.
Very well.
The stress is always there that you have to give me prior. That is there, my lord. I can't run away from that. What is there is there. But this is what they say, that this shall not be treated as a transfer if the entity remains the same. Now, kindly come to the next page, my lord. And they say, my lord, that 2021, under the circumstances, proposals of the management of SIDCL are placed here under. We may follow the recommendations of so-and-so and so-and-so in the cases which may not be considered as transfer. In case of change in constitution or merger, arrangement and amalgamation of the lessee within its group company, major share must be retained by the original allottee. In these cases, WBSIDCL shall realize the prevailing service charges. And then proposed fee structure, etc., is there. And then this agenda item ends at 22. Board may kindly approve the proposals.
Yes.
So they place this proposal before the board. Now the board considers this at page 23, my lord. This is now the board. Minutes of the 33, that was the agenda. And now this is the resolution of the board. This starts at 23. The relevant is at agenda item number 19 at page 24. Now, my lord, kindly see. The board discussed and recorded the recommendations of so-and-so and so-and-so regarding transfer and surrender of lease. Then they recognize what all good deeds they have done. Goes on till 25. Yes. Then terms and conditions, everything they discuss. Then general policy is there. And then kindly see at the bottom.
Under general policy, the second paragraph onwards.
Yes, yes, my second.
Second also, prior
second,
approval.
yes, 10,000, yes. It says prior approval. The following cases are not considered to be transferred by the lessor only upon examination of the applications for prior intimation made to the lessor for the same by the lessee. ও চিঠিটা বার করুন।
But this non-consideration as transfer, as per their language, is upon prior
intimation.
for examination of the prior intimation.
Now, Malad, they've done this examination of
Unless there is a prior intimation and examination of that, it
Now, in
cannot
our-
be waived.
No, Malad, there's no provision for waiver here, number one. And number two, in my
Consideration as transfer.
yes, but in my case, they've done the consideration now. In my case, they've done the consideration.
There was no prior intimation.
There was no prior intimation, but upon intimation being given,
Yes.
they embarked upon this consideration. Then they could have said that since prior intimation not given, we will not do the consideration.
So suppose if we constitute like this,
Please go
not
ahead.
considered to be transferred, the following cases are not considered to be transferred by the lessor only upon examination of the applications for prior intimation made to the lessor.
Yes.
Now, only if there is a prior intimation and an examination of that application, then only it will not be considered as a transfer. That is one of the possible interpretations of this clause also. The following cases are not considered to be transfer, although R should not be there.
Yes.
It's unhappy English maybe construction.
Yes.
But the following cases are not considered to be transferred by the lessor.
Yes.
When only upon examination of the applications for prior intimation made to the lessor.
Yes.
For the same by the lessee. If there is no application for prior intimation and examination, then this cannot be not considered as
Well,
transfer. That may be one of the interpretations.
Yes, but Malo, that is
But
not
still
the-
there is no sanction for that.
No, and still
No, it will not be considered as a transfer.
they don't say that. There must be a Malo, there must be a default that if you don't do this, I will charge it as transfer fee, even if you're following within this. There must be a strict construction in that case, that the consequence of not doing a mandatory act must be stipulated. If there's no consequence of doing an act or not doing an act, then that act is not mandatory. That is, Malad, now perhaps.
In your writ petition, you have also challenged, you have also sought to prefer a challenge against, are they holding that you are not a transfer, not a lessee anymore?
No,
Are they
they're
doing
not-
that?
they are
That is not a question involved here.
That is not a question. They don't say.
Only the question of the transfer
Fee.
fees paid.
Only fees. And Malad,
Then I mean, this is redundant. I mean,
this is
prior-
redundant because it's only because they say now that yes, you fit the bill. Because they asked for my documents. Kindly see the letter, Malad.
So otherwise, yes, there are several.
There are several protracted communications between me and them where they ask for the documents, that show me your documents which would show that you're this. Kindly see one letter, Malad. The first letter which they write at page 100. This is my application. Kindly see the documents which they ask for. If it was mandatory, which I say it is not, prior is not mandatory. If it was mandatory, they waived it by this very letter of theirs. Kindly see.
Yes.
Your letter number so-and-so dated 15 July. This is the first letter which I write, my lord, requesting for transfer in my name. And kindly see the requirements now. You are requested to submit the following: present shareholding pattern before and after amalgamation. Memorandum of article of association of both the companies and MGT7. Memorandum would show who are the promoting directors, my lord, who brought in the company. Name of directors and shareholders with percentage before and after amalgamation. ID proof of all directors, shareholders. Please note your prayer will be processed after written. So here they are considering post facto. After doing post facto consideration, now they cannot turn the clock back and say, you should have come for this on this ground earlier. And keeping in mind, my lord, I would still say, I could have done it, but your lordship sees the practical side of things. It would have been an idle formality. This approval would never have come. The reply would have been this, that according to us, the lease stands terminated and the matter is sub judice. There could not have been possibly any other reply. Given the belligerent stand of the corporation in challenging the ad interim order itself, and then taking the matter up in appeal.
Right.
The
There has
law
to be
does,
two ends of that
yes,
exercise.
and the law.
Two
law-
ends.
yes.
Your end would have been, I mean, you would have sent,
Yes.
but they couldn't have accepted.
They wouldn't.
As per
They,
this.
there was no scope of acceptance.
Yes.
There was no scope of acceptance for them. That would have made the lease, the appeal would.
Obviously,
Yes. So, Manat, their first letter, and then, Manat, there's a subsequent letter. I'll put all this in my list of dates. I've shown your lordship this. But this clause does not have a effect. Not doing this will result in this.
That is not there anywhere.
It's not there. And your lordship sees the discussion from page 20 to 26 of the board goes to show their policy is to be industry friendly And that is why this comes in. The judgments of our court say you have to pay the transfer fee. That was the stand the board took then. Obviously, they faced resistance from the industry that by doing this, you are restraining us from expanding. Amalgamation merger results in a bigger entity with more resources. So this is a hindrance for us. So they reviewed it and they came to this policy decision.
What is the change from those cases? I mean, in the scheme?
There was no scheme. This policy was not there. This is
Policy was, but a similar policy was discussed.
there
also.
was no policy discussed. Kindly see only the clauses of the lease. There's no
Oh,
policy.
right. Yes, yes.
This policy was brought in. It is like my lord, the legislature goes and legislates something to get over a judgment.
Exactly. Yes. So
It
this was, yes, right.
This is that
So the entire clauses of the lease have to be, obviously, those are circumscribed now by the policy.
by this policy. And clauses of the lease are not coming in my way, my lord, because they don't say lease shall stand terminated.
They have not terminated your lease also.
No.
Neither have they taken a stand in any of the companies.
No, they only say you have to pay this amount. I accept you. The minute they accept me, that means that they have no objection to my entity as such.
Right.
But only because you've not taken prior approval, I will charge the transfer fee.
Yes.
Those are my respects. May I file a short note, my lord?
Please file a short. Thank you so much. Yes. Arguments are concluded. Written notes on behalf of the WBSIDC today be kept on record. First up, you will file your written notes when, Mr. Thakkar?
My lord, by Monday. Today is what day?
The matter will,
Friday, my lord.
but the matter will be listed next on August 25, 2023 at the top of the list for filing of written notes of arguments by the petitioners.
Grateful.
Thank you.
But this argument that Mr. Thakkar has advanced in his reply with regard to the policy, may I just file a one-page note on that?
Reply to
Because-
that will be a reply to reply then.
Not reply to reply, because Lord, he did not highlight this point when he
Of
argued,
course.
Lord, initially.
I did,
He
my
said,
lord.
he talked about the policy. I have dealt with the policy. I have said that this prior consent is necessary because, Lord, this policy is in line with section 108 of the Transfer of Property
Yes,
Act.
yes.
I made my submission.
So have you not recorded?
Yes, I have dealt with it in my written submissions. I have already dealt with it.
That is sufficient.
Grateful, my lord.
Thank you.